Test admissions, item number 1. Got it. Item number 1.
Lordship. May I please, your Lordship? Fast matter.
Yes.
Fast matter.
Yes.
Your Lordship, previous order, your Lordship may see. It's the affidavit dated 27/7 has not been supplied to us. So I could not get that, and I could not intimate to the senior advocate. So I pray that affidavit dated 27/7 be supplied today in course of the day, so I can transmit to my senior advocate.
1 minute, Mr. Sahu, are you there?
I'm sorry, I was muted. I'm sorry. Lordship, on 20th of 27 it was served.
No, it is not served. It is not served on me.
So I will not join issues there, my lord. I will again serve it.
No,
You are noting, my lord.
Affidavit dated 27 July 2021 be served on Mr. Nanda.
Other matter.
Itself.
That is regarding the death, my lords. That's regarding the death. Regarding vaccination for elderly and the disabled. That direction, as per that direction, they were supposed to give an affidavit indicating in details how they have proceeded with the matter, giving figures.
Sir, it stands adjourned to 7th of September. And the order was a little bit delayed in uploaded, so it is not listed today actually for second matter. Lordship, may kindly mark the noting in the list also.
Yeah, both will take it on 7th.
okay, my lord. Let it be served on me.
All right. Take on 7th. All right. Item number 2.
Yes, Lordship, I am appearing for the State Pollution Control Board. Your Lordship has asked for the instruction on the notification filed by the Petitioners Council. It is a draft notification, your Lordship. It is a draft notification.
That last order is to be complied by the pollution control.
Doing, Mr. Lord, I am appearing for the petitioner. Lordship would kindly see this notification is dated 23rd of March 2020 and 60 days period was given for the objection and consideration of the same. In the meantime, 60 days over. It is for the Ministry Forest and Environment should come back and say what has happened thereafter, whether this notification is finally published or not. If not, then other courses has to be followed by.
Yes.
Mr. Padi,
Central Government Council.
Central Government Council, Ministry of Forest and Environment.
Yes, yes, Mr. Padi, are you appearing?
Yes, Mr. Padi.
Yes, my lord.
Yes.
What are the instructions? What are the instructions, please?
Sorry, my lord, there is interruption.
Mr. Padi, what is your instruction?
Mr. Padi, are you able to hear us?
Yes, now it is audible.
So what are the instructions?
Well, I didn't have any instruction, my lord. Let's make it
Item 2, Iftikhar Ahmed.
Just now I came to know that, yes, one of my CGCs entered appearance. Let's make give direct me to let them serve a copy of the same. Then take the instruction.
Your counsel, Miss Babita Sahu, is appearing.
That is in the
Yes, her name is there.
That is in the second matter. Yes. In the first matter, your Lordship has passed the order to seeking instruction from the Government Council.
Both the matters.
Both the matters, right. All right, Mr. Padi seeks some more time for instructions at his request. List on. The 7th September.
Well, in the first matter, we have filed the counter affidavit today. In the first matter.
Oh, I see.
That may be accepted.
All right. In the first matter, you say counter affidavit filed on behalf of the state is placed in record. Mr. Rathore, you have copies?
Yes.
Lord, I have received copies. I have received copies.
All right.
Lord, one interim order to be extended till next year.
Yes, interim order to continue.
Lordship is fixing to 27th.
27th.
Obliged.
Item number 3.
May I please? The petitioner is 75 years old.
Interim order in the first matter.
1 month time kindly allowed to get instruction, my lord.
1 minute, 1 minute.
No,
Item 2, there's no interim order.
I think in the new matter, there is a interim order not to take any coercive
I
action.
see. All right.
In the new case.
In the connected matter. All right, all right. All right. Item 3. Item 3.
My lord, in this matter, my lord, the petitioner is 75 years old, my lord. He has submitted his return for the assessment of 2021, my lord, where the refund from 8 lakhs of odds has been granted, my lord. But for there was a demand for assessment 18 and 19, against which he has filed an appeal before the appellate authority and also deposited 20% of the disputed amount. But there is a notice under 245 by the department, and that in response to 245, he has already responded that he has already paid the 20% disputed amount. But the remaining amount, 18-19, has been taken by the department forcibly from the refund of the 2021, my lord. In that context, he has also submitted application before the authority for consideration why his refund has been withheld without assigning any reason. They have adjusted my entire amount, my lord.
Mr. Chimanka.
My lord, 1 month time kindly allowed to take instruction, my lord.
All right, notice Mr. Chimanka accepts notice on behalf of opposite parties and seeks 1 month's time for instructions.
Extra copy may kindly serve, my lord.
Another copy of the petition be served on him today itself. List on 4th October.
So orders item number 4.
Small modification, my lord.
We saw that. Correct, correct.
Annexure 3 is the implement order, my lord. Appeal lies against that.
Correct, correct, correct.
But during pendency,
So you filed another petition for that.
yes,
Oh, I see.
Against the
This is an application seeking correction to the order dated 10th August 2021. In the present application, it is pointed out that against the statement dated 23rd January 2020, issued under form SVDLRS DRS 3 by the designated committee, the petitioner has filed a separate petition, that is Writ Petition Civil 8116 of 2020, which is still pending adjudication. Paragraph. Accordingly, the order dated 10th August 2021 shall now be modified to read as under. The whole of para 2, you just omit para 2, renumber para 3 as para 2, and you say in view of the, you say the petitioner seeks leave to withdraw the petition with liberty to file an appeal before the SESTAT in accordance with law. Then the remaining can remain same.
original orders may be original orders may be returned back.
The original order will be returned subject to being substituted in the attested photocopy there.
Urgent copy.
Item number 5.
Lords, item 5 have just been requested by Mr. Kanungo, who is appearing for the petitioner. My lords, his father is unwell, he is in a personal difficulty, he has requested me to convey it to your lordships.
I see. Mr. Kanungo for the petitioner is some personal difficulty today.
There is for no notice. I have already entered appearance, my lord.
All right. List after 12 weeks. All right. Great.
Item number 6.
Item number 6, my lord. In this case, I am appearing for the petition of my lord railways.
You have to speak into the mic.
But in this case, I am appearing for the petition of my railways. My lord, here 3 different orders has been passed in the similar read petition, my lord. I am giving a list of those cases, and also I have filed review petitions, my lord, in the connected cases.
So this also be dismissed so that you can file a review.
Lordship, my lord, no, my lord, it is on different footing, my lord. 3 different type of orders has been passed. My lord, I pray this may be taken up 1 week after, along with those cases, so that in my lord,
what is the stage of those cases?
My lord, stage of those cases, my lord, I am making it clear, my lord. One, this is a my lord, case of challenging the order passed by the London Central Administrative Tribunal. The order passed by the London Central Administrative Tribunal giving my lord employment to the petitioner, the my lord, opposite party, who are seeking employment under rehabilitation assistance scheme in lieu of, my lord, acquisition of the lands, my lord, by the railway project. My lord, my lord, they were not entitled in view of the railway guideline, but tribunal had earlier rejected. But this honorable court passed order, my lord, in view of an applicant giving retrospective effect of that circular, my lord. So, my lord, against that order, my lord, the railway had moved the honorable appeals court, and honorable appeals court dismissed on the ground of limitation, my lord. Thereafter, my lord, that applicant was given employment. Subsequently, my lord, others came, those who are fence sitters, my lord, they came and challenged before the filed original applications before the Central Administrative Tribunal. My lord, their applications were also allowed, and this was challenged before this honorable court. The honorable court, relying on another repetition judgment of the honorable appeals court, my lord, passed different order. That
what is different order means what? They allowed dismissed what they do.
There, my lord, the earlier order where, my lord, this honorable court passed the order to give, my lord, employment without conducting any selection. But in another project, the honorable appeals court passed the order, my lord, rehabilitation appointment will be given to the land users, my lord, in the process of selection, my lord. This is the reference, my lord, without selection and with the selection. This is the distinction between two orders, my lord. And without, my lord, conducting any selection, if employment will be given, it will be give a fraud gate for, my lord, a small piece of land is acquired, my lord, that will be given, my lord, given employment. Well, that circular has already been modified by subsequent circular of the railway board, which provides, my lord, without employment, they will be given 5 lakhs rupees, my lord, in lieu of compensation.
What is the order here, please?
Order
page
here,
71. Come to page 71.
Lots, my lord. I am bringing.
Nothing. Since you asked me to reconsider that.
Page 69, my lord, page 69. The order passed by this honorable court, my lord, in another repetition. Lordship, page 69.
So your case is that 2010 circular is not applicable?
Not applicable. My case, my lord.
Because it has been given, it cannot be given as a retrospective.
Same point is involved in the other matter too.
So in that Krishna Chandra Nayak's case, what happened?
Same point.
My lord.
In Krishna Chandra Nayak's
the land was acquired, just see para 13.
My lord, what happened?
Krishna Chandra Nayak's page 71, the quotation para 13.
Yes, my lord, that has been quoted. But subsequent circular, lordship, kindly see, this is the distinction, my lord. We the
para 11, 3, 11, 12 and 13. This is just because land was acquired prior to 1607, you can't deprive him of that.
My lord, land acquired in the year 2000.
Same point. So they've already decided it, and they're simply following our order. SLP against this order has been dismissed. Then what is wrong with that?
My lord, land has been decided acquired in the year 1999, and payment has already been made by the year 2002.
Sir, all these were the same facts in that Krishna Chandra Nayak's case.
No, my lord, my humble contention in this case, your lordship, kindly see, by the date of passing of the tribunal's order, there was another circular. My lord, Annexure 4, page 72, lordship, kindly have a glance.
That is of
they have
2019.
My lord.
That circular is of 2019.
19, my lord. Before passing of the tribunal's order. So, my lord, my contention is that, my lord, by that time.
Did you file an affidavit bringing that circular to the notice of the tribunal?
Have you brought it to the notice of the tribunal? 2019 circular.
I don't have instruction, my lord.
Where is the ground where you said I brought it to the notice and the tribunal did not see it?
My lord.
All right.
No, you have not taken that ground in your application.
My lord, in the I have annexed the
No, you've simply annexed it. You have not said we place this before the tribunal, despite which the tribunal did not see it.
So that has not been that.
Because you did not do it.
Has not been taken, my lord, in our minds. My lord, I will take instruction, whether by subsequent affidavit or submissions, my lord, it has been brought to the notice of the honorable tribunal. My lord, I will take instruction on this. And also.
No, again, these petitions were filed long ago. This particular Devnath Das, the application was filed in 2014. No, while the petition is pending, you bring out the circular.
Yes, my lord.
So how can you wipe out everything in the past? Even this circular will have only prospective applications then.
Yes.
So it does not improve your situation.
Well, my humble contention is before the honorable Law Tribunal passes the order, my lord, in this case, relying on this honorable court's order, my lord, the circular was modified. By that time,
you have not brought that. First of all, you did not bring it to the notice of the tribunal. All right. Second, the new circular also will have only prospective effect.
This must have been given, my lord, brought to the notice.
Now you can speculate a lot of things. You did not do what you had to do. You did not bring it to the notice of the tribunal. Admittedly, the special petition against this court order has already been dismissed by the Supreme Court of India. In that case, the matter, the court sees no ground made out for interference. The petition is dismissed.
Item number 7. Item 7.
Hello. But in this connected, all these connected writ appeals, the impugned order, my lord, in first writ appeal, lordship may say at page 57.
First day order.
First day order.
But same thing. Are you appearing, sir? Do you know who is appearing?
The petitioner's counsel is Pradeep Kumar out in all these cases.
All right. Notice on application for delay, there's delay.
Yes,
Obviously.
107 days.
And appeal. Additional copy we served on counsel appeared for the opposite party number 1 before the learned single judge. It's a notice only to, the others are not necessary.
Orders are pro forma, my lord, only to,
they're only pro forma, right?
Yes, ma'am.
Yeah, notice only to opposite party number 1. List on 13 September.
Item number 8.
Lordship, sir, this is a writ appeal, my lords. The single judge's order, my lords, was passed on the first day itself. I was not served a copy also of the writ petition, and the order, my lords, has been passed, which directs me to allow students to prosecute their studies without payment of any fees for the academic year 21-22. My lords are aware, I rely on the judgment of the Indian School Jodhpur, which clearly says, my lords, that my lords, in Indian School Jodhpur, the Honorable Supreme Court has passed on the judgments, my lords. Your Lordship may Lordship is perhaps
no. What the single judge has asked is that you should comply.
Yes, my lords.
With the order dated 29 July 2021.
Yes, my lords. My lords will for a moment have the 29/7 letter, which is at page 41, where the district education officer instructs me to allow students to prosecute their studies without payment of fees. And my lords are aware, this Indian School Jodhpur, my lords, clearly at para 107, your lordship may kindly have for a moment.
No. So you did not go to the court challenging this, correct?
My lords, this is a request letter. If your lordship will see, this is a request letter. 4th of August, my lords, is at 152, my lords. I gave a detailed reply. This reply, my lords, was not annexed in the petition, writ petition.
And so you had no opportunity to keep this, place this before the single judge. Sorry, my lord. So you had no occasion to place this before a single judge.
My lords, in fact, no, my lords, actually I'm wrong. page 43 shows that they had annexed it in the writ petition. I'm wrong, my lords. Now, my lords, there I point out to the Honorable Single Judge that we have made our response to the 29-7 letter. Despite that, there is a direction that you comply with the 29-7 letter. Now, my lords, what is happening here?
After your response, you did not go to the court.
No, my lords, we gave the response. It's a request letter. We gave the response. It's a request letter. It's not an order also. By virtue of the Honorable Single Judge's order, my lords, it has assumed the character of an order. And your lordships are aware, your lordship, for a moment, if your lordship will have page para 107 of that judgment I am referring to, my lords.
You are not an aided school, is it?
No, my lords, it's a private unaided school.
Oh.
I am a charitable organization, my lords. My lords, fixed costs.
When does your term begin?
My lords, the admission process, my lords, got over on 31st May. I have been, my lords, I'll just apprise your lordship. Under law, I am guided by the 1996 resolution which provides for the NOC. That says that fee revision should be in consultation with the parents. My lords, I make consultations from 14th March to 14th May. Cross correspondences have been happening with parents. Ultimately, my lords, I say that 31st May is the SME department's guideline which says that all admissions have to be completed by 31st May. We are still discussing fee hike. So ultimately, my lord, that fee hike, and what is the fee hike, my lord? 300 rupees per year. I have a chart also, if your lordship wants, can have a look at it. The fee hike is at page 76.
No, right now online classes are on.
Yes, my lords, online classes are going on.
No, these students are attending.
No, my lords, what has happened, they have also suppressed the fact that their admission, they have not fulfilled their admission procedures. So how can they, they have to first fulfill the admission process. That also they have suppressed in the writ petition. That is the problem, my lords, when I am not served with the writ petition. I have served with the writ petition, my lords, at 3:30. The order was passed at 11 o'clock in the morning. After the order gets passed, I am served with the writ petition. After that, I see all these things, my lords.
But you appeared and you made.
I appeared, my lords, on information that they served. Sorry, my lords.
Your submission has been recorded in the.
My lords, my submission, my lords, was that I have objected. I objected to the 29-7. Your lordship will have the order, my lords, impugned order, page 40. Counsel for opposite party number 5 contended that since the dispute is with regard to fixation of fee structure for the academic session 21-22, unless the matter is resolved, it will cause difficulty on the part of the institution to prosecute the online teaching. In any case, pursuant to letter dated 29-7 of the DEO, the school authority has also intimated the DEO expressing its inability to allow the students to go for online teaching. Whatever limited information I have, I had the letter of 4th of August with me because that letter, my lords, to be fair, was drafted by me. So, my lords, I had the facility of that letter. On that basis, I made the submission. I was not given a copy of the writ petition, my lords. And I have stated so in my.
Who is this daughter of Shri B.K. Dodka?
My lords, B.K. Dodka is one of the parents who has been making, I'll not go into that, my lord, but he has been making defamatory statements against the school.
I see.
I'll not go into that, my lord. My lords, what is happening, my lords? Your lordship will have for a moment. I have given
So what we'll do, Mr. Acharya, is
yes,
we'll give you notice at a short date. Let's not stay this order.
No, he is there in the petitioner's council.
My lord, I am coming after seeing my name is not reflected. However, it is very most unfortunate by the school authority and also the conducting council. On that date, they have appeared so motto and stated all things before.
1 minute, 1 minute. Sir, just answer one question. When they appeared, did they have a copy of the writ petition?
My lord, he has argued the matter.
1 minute. Why don't you answer the question, please? You answer us honestly. There's no difficulty on that.
My lord,
Did he have, when we argued, did he have a copy of the writ petition?
my lord, I am fairly stating that on that date he has rendered appearance as per.
Sir, I'm asking you now for the second time.
No, my lord. I do.
I am as a 1 minute.
Well,
am I being clear? Am I audible?
Yes, my lord. I am.
Kindly answer the question. This is the last time I'm going to ask. Don't go around the world answering this.
My lord.
When he appeared and argued, did he have a copy of the writ petition?
No, till that date I do not know he was the conducting counsel of the authority.
So he did not have 1 minute. So he did not even have a copy of the writ petition.
And so he did not pray for adjournment for seeking copy, my lord. While the court adjudicating the matter, he has stated, my lord. Must simply my prayer to my lord. Your lord.
Question number two. What is the fee hike?
My lord.
What is the fee hike?
76.
No, I am asking.
My lord.
What was the hike?
Percentage that has been hiked, my lord, without consultation of the that.
You tell us in rupees and paise. You tell us, sir, fees is so much. Now the hike fee is so much. You tell us that.
For accurate, I have to take instruction, my lord.
You don't even know what the hike in the fee is.
Well, Lord, hike.
You have filed a whole petition. The whole petition is this hike is unreasonable.
Yes, my lord.
You don't even know what's the fee hike.
Yes, my lord. Yes.
Because the order is totally silent and we don't understand what is the hike in the fee from the order.
My lord,
what is the hike in the fee?
My lord, the percentage, as per my instruction, I could not.
So it is 1 minute, please. So you don't even know what you are protesting against. Is it a fact you don't even know what you are protesting against?
Yes, that is, my lord, in my writ petition. My lord, take copy. I will sort upon me on Monday. I will on affidavit. I will say everything. What is the role of the?
So now you realize, right? Today, suppose we dispose of this writ appeal without even copy to you. Will it be fair? Are you now realizing what the first point of argument is?
My lord,
you have argued.
All right,
I will simply say, no, Mr. So-and-so appeared for the respondent. Even without copy of writ appeal, you argued all this.
No, my lord.
Then he can argue in the Supreme Court, sir, what is the difficulty? He argued.
No,
although he did not have copy of writ appeal, he argued.
Myself, I am doubting myself. Similarly, I am seeking copy.
Exactly. So the first, therefore, exactly, you've come to the point now.
My lord.
Therefore, you've come to the point.
My lord.
So without a copy of the petition even being served, writ petition is disposed of.
So, my lord, my learned friend on that date, particularly, he is not seeking copy and object the petition, my lord. The court has gone to that extent, my lord, only to that your lordship, even if they have issued the letter to us, where it is my with record with my.
If you agree, sir, if you want to, there are two options now.
Well,
since you do not dispute that he did not have a copy of the writ petition, you agree that you will go back to the single judge. Now he has a copy of the writ petition. On the date we fix, he will already file a counter affidavit. All right. So that he doesn't take time for that. If you so agree, I'll ask him to file counter affidavit 1 week before the date we fix. You also file a rejoinder by that date. The matter will be heard afresh. If you agree.
My lord, one thing, I agree with this proposal, but with the condition, my lord, that at no point of time, the parents are not disputing to give the fees, my lord. What I have.
So should I also record that your issue is not with the fees? I will record that.
No. My lord, the parents are requesting that let the students are allowed to this, and as per the teachers' parent meeting with the authority, it should be decided as per the law. My lord, there is also even if the notification of the state government, my lord, which my learned friend is clearly aware that the school management shall not debar any student from attending either online classes or physical classes on account of the non-payment of fees, arrears and outstanding fees, including the installment referred to above, and shall not withhold the result of the examination of any student on the account, my lord. That is the notification of the state.
For
After-
2021.
Yes.
I am on 21-22.
That is the.
No, what is the notification for 21?
Yes, my lord, notification is number 10215, dated 3/6/2021.
I have a next.
3/6/2021, my lord. It is the settled, and that has been binding upon the authority of the school, my lord. And the students who are reading in the classes, they are debarred from the education.
So there are only two options.
My lord.
There are only two options. If you insist that you want to argue the writ appeal itself, we'll issue notice, we'll ask him to serve a copy of the writ appeal on you, and we'll stay this order and we'll set it down for hearing. All right. Because the ground for staying is very strong, because you have admittedly, you yourself admit that you did not have a copy of the writ petition when the order was passed.
Yes, sir. Yes, sir. Honor may remand to the single judge, my lord. But my own submission, all the documents, even if my learned friend admitted before the court, we will openly
you tell us what is the
student.
Since you
Therefore, the court has
1 minute
directed to that. Then,
Mr. Pati, kindly listen to my lord.
my lord, my lord.
Since you very fairly say that these parents are not interested in not paying fees, you say the issue is not about fees, correct?
Regarding the hike fees, we are objecting.
Only hike here of. What is the hike? Hike is 1 lakh, 2 lakh.
No.
What is the hike?
Your lordship remand to the single bench.
No. Will you pay the fees? Will you not pay the fees?
My lord, even if the petitioner who is the Vijay Dodka, his two daughters are reading, at no point of time one daughter is passing away from the school, at no point of time they have not objected this. This is the pandemic situation, what are settled by the honorable.
You tell us, sir, suppose the hike, just giving you an example, I don't even know, because neither the order of a single judge nor you are able to tell us what the hike is, right? According to him, the hike is 300 rupees per year. The hike is 300 rupees per year. All right.
76, 76 is the chart. Lord sees column C and column F. And my lords, another important aspect of this hike is the fee structure of 2021 is the same as 1920 because of the Honorable Supreme Court's direction not to hike fees during 2021. So fee structure is of 1920 versus 21-22. So after 2 years, the hike is 300 and whatever the 150, that is the hike.
So the monthly incremental fee is 150 rupees.
Yes, my lords. That's why I wanted to show to your lordships.
Can we record this? If this is the monthly hike.
My lord, I will take the instruction. On that date, I have no.
How can it be, sir? You argued this writ petition. This is what is astonishing us.
Your lordship,
on what document did you appear and what document did you argue?
Your lordship, my humble prayer. As your lordship remind that we will give the everything, or otherwise a copy may be served. I will place all the documents on Monday.
All right.
Which is a.
All right. You see, Mr. Acharya, learned counsel, appearing for the appellant, points out that the impugned order was passed by the learned single judge at the very first date of the hearing of WP Civil 24132 of 2021, which was filed by opposite parties, respondents, 1, 2, 5, who are today represented by Mr. Pati, Mr. M.K. Pati, learned counsel. Stop. He states that while the order was made at 11 a.m. in the morning, a copy of the writ petition was in fact served on him only at 3:30 p.m. And therefore, even while he made submissions which are recorded in the impugned order, it was on the basis of the submissions made by Mr. Pati for the writ petitioners and without a copy of the writ petition. Paragraph. He further points out that the actual hike in the fees, which was for the academic year 2021-22, in terms of the calculations at page 76 of this writ appeal, works out to rupees 300 per annum as regards the readmission fee or the term fee from class pre-nursery to class 3, rupees 50 for classes 4 and 5. Class pre-nursery to class 3 and class 6 to class 10, and rupees 50 for classes 4 and 5. And after accounting for the sanitization fee, the monthly fee, the actual increment in the monthly fee works out to rupees 150 per month for classes pre-nursery to class KG, rupees 200 per month for classes 1 to class 3, rupees 50 per month for class 4 and 5, rupees 100 per month for class 6, rupees 70 per month for classes 7, 8, 50 for class 9 and 20 for class 10. So for classes 11, 12 in different branches, the range is between 420 to 890. 2021 was in fact replied to in detail by the appellant on 4th August 2021, which too has not been discussed in the impugned order of the single judge. He also relies on the judgment of the Supreme Court in Indian School in Jodhpur versus State of Rajasthan, 2021 SEC Online, SC 359, to urge that there cannot be a blanket order for admission of permitting students to pursue their course online without payment of any fees whatsoever, and more particularly without complying with the other conditions. Paragraph. Mr. Pati, appearing on behalf of opposite parties 1 to 5, was specifically asked whether in fact a copy of the writ petition was served on Mr. Acharya, counsel appearing for the appellant, who was opposite party number 5 in the writ petition, only at 3:30 p.m. on 16th August 2021. Full stop. He answered in the affirmative while urging that Mr. Acharya had not asked for a copy to be served while he was arguing the matter before the learned single judge. Paragraph. In view of the above statement of Mr. Pati, it is evident that even without a copy of the writ petition being served on opposite party number 5, the impugned order has been passed with a direction to opposite party number 5 to comply with the letter dated 29 July 2021 of the DEO without even a copy of the writ petition being served on it. Paragraph. Mr. Pati then states that he would like to reply to the writ appeal on the issue of the hike in fees, and states that the matter be taken up on some other day. Paragraph. A copy of, you say, notice, Mr. Pati accepts notice for opposite parties 1 to 5. Is Mr. Parida here or Mr. Mahapatra?
Yes, my lord, I'm here.
Ms. Mahapatra accepts notice.
6, 7, and 6 to 8.
Right, for 6 to 8. Replies, if any, be filed. Full stop. Paragraph. The court pointedly asked Mr. Pati if he would prefer that by consent the impugned order be set aside to enable the writ petition itself to be taken up after completion of pleadings in a time-bound manner before the learned single judge. Full stop. Mr. Pati then said he would want to take instructions and respond to the writ appeal. Paragraph. The replies now be filed within 2 weeks and rejoinder for the next date in the present appeal. Till the next date of hearing, there shall be a stay of the impugned order of the learned single judge. List on 4th October.
On the last time, I also, because it will linger the matter, students will be suffered.
You make up your mind. So, Mr. Pati, I think therefore we gave you enough time to reflect.
No,
I think I asked you twice this. I repeatedly asked you, should we send it back to the single judge?
I am ready to do back to the single judge, my lord. I have already stated, my lord.
How after
No, my lord, I have stated, my lord, your lordship.
at the last is.
This is not being fair to the court, Mr. Pati.
No, my lord.
We repeatedly asked you. We knew this is what was going to happen in the end. So we asked you in the beginning.
My lord, your lordship, while asking me, I could not have such instruction. Therefore, if your lordship is preferred, let it remand back to this, or otherwise, a copy may be sought out of me. Verify, my lord. Your lordship.
We will consider on the 4th.
Actually, it can go to the single judge on the 4th. Okay, we listed before the single judge on the 4th, by which time his reply, your rejoinder will all be on record.
My lord.
No changing your mind now on this.
No.
You better give him a copy of the right now.
I'll make one and immediately get it.
You see, after the first thing that you say, since it is plain that the writ petition was disposed of on the first date without even a copy of the writ petition being served on counsel for the present appellant, like it was opposite party number 5. With the consent of Mr. Pati, the impugned order is set aside. No, Mr. Pati states that he would prefer that the matter be remanded to the learned single judge for being argued after completion of pleadings. With the consent of Mr. Pati, the impugned order is set aside, and the following directions are issued. 1. Writ petition civil number 24132 of 2021 will be listed before the learned single judge on 4th October 2021. 2. At least 1 week prior, not later than 1 week prior to that date, the present appellant will file its parawise reply to the writ petition with an advance copy being served on Mr. Pati, who is permitted to file a rejoinder thereto before that date. Likewise, opposite parties 6 to 8, respondents 6 to 8 to the present appeal, that is the SNME department, the DU and the DU, will file their replies at least 1 week prior to the next day, prior to 4th October 2021, and rejoinder thereto by both opposite party number 5 in the writ petition as well as the petitioners will be filed by 4th October. Paragraph. None of the parties will ask for any further adjournment for the above purpose. Next, the learned single judge is requested to proceed with the hearing of the writ petition on merits and endeavor to dispose it off as expeditiously as possible thereafter. The writ appeal is disposed of. You say it will be open to the parties to argue afresh on the question of interim relief in the writ petition. On fourth, you can argue for interim relief.
Why?
For respond number 6 to 8, my appearance may be noted.
All right.
My appearance is already noted.
All right.
My lords may also observe, if your lordship feels fit, that I'll serve a copy.
Yeah, the copy of the writing release a notice, all of them accept, copies of writ appeal be served today itself. Then you say, no observation in this order is to be construed as an opinion, expression of opinion and merits of the issues before in the writ petition. Right. Grateful.
Item number 9.
Mr. Joseph can taken up next week, Malas.
Why? अरे microphone ले कौन तुम?
Like he is badly placed today, Malas. He is badly placed today, Malas.
Badly placed. कौन badly placed? But Mr. Joshi is badly placed.
Yes, Malas. Only placed.
This is for final hearing the appeal. TCR is available.
21 appeal.
All right, Mr. Joshi is stated to be in some personal difficulty. List after 12 weeks.
Item number 10.
For 2 weeks? 12 weeks.
Item 10.
May I please, your lordship. In this case, I have challenged the interim order at annexure 6 to Honorable Tribunal, Principal Bench, Bhubaneswar, my lord. The ground that the case is filed only to regularize the service of the petitioner from the date of initial appointment. That is a completion of 6 years in contractual basis. Only for antedating the regulation. So in this regard, number of cases has been decided by this honorable court. In writ petition by the division bench, in writ petition number 37783 of 20. My lord.
Yes.
Another case in single bench, that is 34606 of 20. So we said the above facts kindly turn to answer 8 page 41, my lord. Even if after touching up in similar cases, Kotak bench said Kotak bench has passed on several orders, and that has been implemented by the authority as page 42, my lord. In person to letter number so and so, the health
What
and
is your
family
initial
department.
date of appointment?
My date of appointment
21/8/2015.
21/8/2009, my lord.
Claiming regularization.
Regulars. I'm brought out to the regular installation 12/7.
Initial date of appointment. Your initial date of entry
is
21/8/2009.
21/8/2009, my lord.
on contract. So why your period was not counted till?
Because they have stated that we're continuing against the post of NRHM. That's why they are not-
NRHM.
Yes, ma'am.
So NRHM, you are now claiming regularization in staff nurse.
My service has been regularized from brought over to regular installation on 12/7/2012, my lord.
What is your initial appointment order?
That is at annexure 1 series, my lord.
Annexure 1.
As page 14, my lord. My serial number is 16, my lord. Top of the page 14, the select staff nurse of place.
Yes, it is 12 July 2012.
No, my lord. Can you peruse the page 14, my lord? Selected staff nurse and place posting under NRHM Ganjam on 14/8/2009.
Page 14.
Page 14, first line, my lord.
Page 14 is something else. On 14/8/2009.
Yes, ma'am. My serial number is at 16, ma'am.
That is under NRHM.
Yes, ma'am. They have not taken into consideration of the NRHM period. That's why they have regularized my service in 2015 instead 18 instead of 2015, ma'am. My prayer only to regularize my service from 21/8/2015 instead of 12/7/2018, ma'am.
He wants that period has to be counted towards his period.
Oh.
That is so. But once you appointed in the post of staff nurse in 2012, how can you claim that regularization should be counted from that period?
Because number similar cases also in authority has decided in page 1442 kindly peruse, my lord. Similar cases Honorable SAT Cuttack Bench decided in 1901C of 2017. Accordingly, in that case, one Rasmita Swami was the applicant. Kindly peruse the page 42, my lord. In pursuance to letter number so-and-so dated 17/12/2019 of the Health and Family Welfare Department, Orissa, and as per the final judgment of Honorable OAP Cuttack Bench, Cuttack, in connection with OA number 1901C 2017 filed by Rasmita Swami, Bosha State, Odisha, and other have service Srimati Rasmita Swami, staff nurse, is hereby regularized with effect from 13/3/2014 in scale of so-and-so. Prior to that, minor page 41 may be kindly perused. In that case, his service was counted from 26th February 2016 instead of 13/3/14. That has been corrected as 13/3/14, minor as page 42. In similar cases, number of cases in filed, page 43 kindly perused. In that case,
So they have first regularized the case of Rasmita Swami from 2016, but they corrected then to 2015.
Yes, my lord.
Taking into her appointment.
NRHM.
But then, my lord, you'll also make see the operative part as page 35. Now, recovery proceeding has already been initiated, and the concerned CDMOs were directed to initiate recovery proceeding against those employees.
No, come to page 33.
33, my lord.
Para 6.
Yes, my lord. Para 6. At the time of argument, learned counsel for the applicant has further brought to my notice the decision of the Health and Family Welfare Department resolution number 23340 dated 21/9/2010, wherein para 10 it has been mentioned that past service of contractual staff nurses working under various schemes like Swasthya Vikas Samiti, Rogi Kalyan Samiti, NRHM shall also be counted for computation of 6 years at the time of regularization after their absorption against the post of contractual staff nurses under general healthcare, subject to proper verification of documents by appointing authorities. Now that has been clarified by the same judgment. Lords may
it can't be clarified by a judgment.
Lord, they have the interpretation, what the learned tribunal interpreted, that it was not made applicable after the new notification came into force, my lord. Because it was there in the 2010 notification was there, when 2013 and 14 notification were not there. So therefore, after 2013.
What is 2013-14 notification?
That is at Annex 23, the regularization part.
25th July 2015.
17th September 2013.
Page
23. There the resolution was passed by the J department, and if the guidelines were framed, how and when the procedure to be followed by the government for regularization of the. Will also may kindly see the second para of page 23. May I read below?
Yes.
Contractual appointments, engagements made against contractual.
No, that you are coming to 13 rules.
No, where does it say that if you work in NRHM, it won't be counted? Where does it say? It doesn't say that.
No, my lord. The petitioner, as per the petitioner, he was claiming that by letter dated 21/9/2010, that is at paragraph 6 of the order, he was entitled to compute the period of
count the NRHM period.
But at that point of time, 2013 and 14 regulation was not there.
No, the resolution does not say that NRHM will not be counted.
But this paragraph says only those persons who are appointed against contractual posts and with the concurrence of the finance department. Now, NRHM posts were not, it's a central government sponsored scheme. It was there is no such.
Where is the prohibition?
Yes, no such prohibition was there, but this is the guideline, my lord. Now,
just let's be clear on this.
my lord.
This resolution does not seem to state that the NRHM will not count. Period during NRHM will not count.
But it is for the entire, my lord, group C and group D post, contractual post, my lord.
Yeah, that is one. The other is the judgments of this court. How do they overcome that? There are judgments of this court. Just see the judgment dated 73/2017 in OA number 2169. And then what did you do against those judgments of the tribunal? Did you challenge it here in the High Court?
I don't have an instruction. But in fact, it was passed to the tribunal, and I'll just,
because that judgment is much after all this.
Yes, ma'am.
You say notice. Mr. Das accepts notice on behalf of the opposite parties and states that he file a reply within 4 weeks, rejoined the next day. Let's stop it.
Item 11.
My lords, in item 11, my lords, land acquisition matter, the land of the petitioner's father. My lord,
speak to the matter.
my lord, the land acquisition matter, my lord. The lands of the petitioner have been acquired since long, my lord. Under Annexure 6, the petitioner has repented, but the opposite parties are not taking in action.
Even for MCL?
MCL, my lord.
No, but is anyone appearing? I think yesterday you passed a similar matter, no? Which year's acquisition is this?
Pardon, my lord?
Acquisition of which year?
91, my lord.
And then what were you doing?
No, my father was in the list, my lord. Your lordship kindly have a glance at annexure. My father was called for interview, my lord. And that is annexure 5, my lord, at page 30.
No, sir. Just come to now para 7, 8, and 9. Para 7, 8, and 9. Just read it.
Para 7, my lord. After verification of the documents, the chief personnel manager, OP note 2 and 3, and 28/7/19 issued the letter of interview. That is annexure 5, my lord.
Read on. Read on. Come next to para 8, then read para 9.
My lord. They didn't give appointment to my father, my lord. Thereafter, my lord, so many other
Sir, I'll only make one more time request. I won't repeat it again. All right. Kindly read without a break, without your commentary. Kindly read para 8 and para 9.
The opposite party didn't give an appointment to Pitabasa, the father of the present petitioner, to the father of the present petitioner, my lord. With mental agony, father of the petitioner died in the month of January 21, my lord. Thereafter, my lord, the present petitioner is son as approached, my lord.
Do you find in these 3 paragraphs any setting out of what happened in 30 years since your father's interview took place?
No, my lord.
Is there a need for you to explain that in a writ petition under 226, or there is no need?
Pardon, my lord?
As to what happened in 30 years' time, is there a need as petitioners for you to state that in your writ petition under Article 226, or there is absolutely no need to explain what happened in 30 years?
My lord, by that time the present petition was not major, my lord. When his father was there, my lord, and his father was running from post pillar, my lord. His father was running from post pillar. He didn't approach, and his father was making prayer. That after his
is it enough?
Yes, my lord. It is the duty of the petitioner. Here I submit, it is the duty of the petitioner, my lord, to approach the authority to consider his case. When his father was not given an appointment, he was aged bar, my lord. It was the duty of the present petitioner.
No, what my lord is asking you, what you are doing since 1991 to 2020.
For 30 years.
Yes, my lord. That is with my lord, with due respect, my lord, the petitioner has not.
You want to withdraw it, you can, because we cannot entertain a petition like this when there's no explanation for this inordinate delay.
only one prayer I will humbly submit, my lord. The present petitioner should approach the OP number 3. The only one more submission, madam. But he has approached the land acquisition officer OP number 4, my lord. Actually, the appointing authority is OP number 3, my lord. May I please?
Miss the point altogether. All right. Counsel, the petitioner seeks leave to withdraw this petition with liberty to,
my lord,
approach the authorities in accordance with law.
Opinion
This case is withdrawn with liberty to
obliged.
Item 12.
The petitioner in this case challenges the award passed by the land acquisition officer, my lord. Against that, my lord, I have filed an appeal before the arbitrator cum district collector Devagad, my lord. And in similar cases, this honorable court, my lord, has also remanded the matter to the arbitrator cum land acquisition collector, that is a collector Devagad, and that is pending before the collector Devagad, my lord. Because as per the provision, there is a as per section 3G5, my lord, if the amount determined by the competent authority on
you withdraw it. You withdraw it to go. If the counsel petitioner seeks leave to withdraw this petition,
not to withdraw, my lord.
Liberty to avail other statutory remedies as are available to the petitioners in accordance with law. This is withdrawn with liberty is paid for.
And still 2 is pending, my lord.
No, stating that you would like to pursue the remedy already availed of by them in accordance with law.
Withdrawal may not be mentioned, my lord, because that is pending before the OP.
That's all. So to pursue the remedy already availed of.
Yes.
Item 13.
My lord, item 13 on behalf of Mr. Bhuya is corona positive. The matter taken over 1 week after.
In this case, we have filed the decision of the collector as per the direction of the court, and another writ petition is not tagged. Similar matter of Mr. Bhuya, WPC 19162 of 2021.
Now, these orders that have been passed,
yes, madam,
are these appealable or what are these orders? Or
this is an order passed by the collector, and he has referred the matter to the R&R authorities. Your lordship may kindly visualize what has happened. They are entitled to certain amount of compensation.
Right.
Due to some clerical mistake, there was a wrong calculation of our, and in fact, by the time the money was handed over to them, they executed an indemnity bond that due to any mistake, if we are receiving any excess amount, we'll refund it to the district administration.
Right.
And subsequently, it was pointed out within a very short while, not that after 1 year or two, within 15 days, AG party pointed out, Accountant General, that there was some excess payment. Then the collectorate itself, they examined the matter, the land action officer examined the matter and found that in fact there was some due to some error, which has been clearly mentioned in the impugned order of the collector in another writ petition, the Mr. Misra filed. And due to some wrong calculation, excess payment has been made. And accordingly, the refund notice was issued. And your lordship in the past that they will file a reply to the refund notice and will pass an order. Accordingly, we have passed order in all the writ petitions. This item number 34 is also a connected matter. And in that item number 34, Mr. Misra has filed another writ petition challenging the collector's order dated 16/8. They have filed this. This is a wrong calculation. The matter has been referred to the R&R authority.
So now they can challenge this order.
These petitioners have not challenged.
I'm saying they can challenge this order.
No, because they have to exhaust their remedy before because there is a court established under section 60.
So that's what I'm asking you. So against this, they can go to the court.
Exactly, my lord.
Just let's see that provision.
Section 64. Your lordship may kindly have a glance over section 64 of the new act, 2013 act.
All right.
Let them refund. If they are really entitled to get some more amount, then they will be entitled to get as per the tribunal's order. Section 64 may kindly be seen.
10 to 28 days.
And in fact, for the knowledge of this honorable court, many of the awardees have already returned to the extent of 2 crores we have recovered. They voluntarily returned, and some of the awardees have filed the writ petition.
So now they will ask the collector to refer.
We have already referred. All the cases we have already referred to the R&R authority, which is judicial district judge. One of the district judges is appointed as the LRR authority, who, like section 18, my lords knows, before in the old act, section 18 was the reference power and sub-judge was the authority to decide the actual compensation to be paid.
Do I understand you saying now on this against 18th August order in this writ petition civil 19166?
Yes, my lord.
Khulana Sahu. against this order of 18th August 2021 of the collector,
Yes, ma'am.
what is the remedy of the petitioners?
Now your lordship may kindly see 18th August order, collector has justified the
Correct.
No, what is
notice
the remedy
for
against
notice
that order?
and refer the matter to the 60.
Against that order, what is the remedy for the applicant?
No, that order strictly saying that is not applicable under this act. This is the administrative order which was passed pursuant to your lordship's direction. That is disposal of the representation. That representation he has given, we have heard them and we have considered all the.
Just come to para 19 of that order, which is passed.
Yes, sir.
Lastly, it is observed
that forwarding the application of the petitioners under section 64 of the act to LA and R&R authority is a judicial authority.
Lastly, it is observed that forwarding the application, you have that?
Yes, my lord. I am reading that. Of the petitioners under section so and so, the act for determination of the proper compensation amount is not connected with refund of the excess amount of compensation paid to the petitioners. The petitioner are entitled to substantiate their case by adducing evidence before the LA authority for higher compensation. But in any case, they cannot be allowed to retain the excess amount of compensation paid to them due to clerical mistake. So, for the ends of justice and fair play, the petitioner is directed to refund the excess amount to the government exchequer as per the refund notice so and so, and at the same time, pursue their remedy for higher compensation before LAR and our authority in accordance with law. Accordingly, the order of the Honorable Court is hereby compliant. That is what my respectful submission is, that if they are at all entitled for higher compensation, the judicial authority has been established.
No, but their case is that they have already made claims before the LAR authority.
No, the
for higher compensation.
Yes, the procedure is they have to file an application under section 64 before the LAO, and LAO will forward it. We have already forwarded it, and the matter is in session before the.
So this is, he separated out the two issues. He says
yes, that is what my responsibility. It is separate issue.
No, suppose they are not they are aggrieved. Naturally, they'll be aggrieved. But he's saying you are not entitled to this package, that package, so it's been wrongly paid to you. So please refund.
My lord, this is not a case of package. This is a pure and simple case of land acquisition. They are entitled for the land.
No, just see this para. 1 minute. I just saw that. Para 15 of the same order.
15.
Since the state government.
Since the state government has not declared any R&R package for this project, therefore the petitioner not entitled for any sum towards R&R package as per section 31 of the act. Hence, the petitioner Biswanath Sahu and the others in respect of so and so is entitled for an amount so and so as compensation as per the following. They are only entitled for the compensation simple land acquisition. There is no R&R package. Your lordship may kindly visualize. R&R package is a different package which is only floated in case of any specific work by the state government. Here is a case, we are only giving them compensation.
No. So what I'm saying is, if this itself becomes a point of dispute, the reference court will not look into it.
No, reference court will only look into the quantum of compensation.
So the only remedy therefore is to challenge this in a separate petition.
Naturally. The finding of the collector.
That's right.
That finding of the collector can be challenged. I don't say that they have they are not entitled to challenge this order of the collector's order cannot be a final order. That I cannot say before your lordship at least. But my respectful submission is that the order of the collector sounds very reasonable, because what he has said that you refund the excess amount and work out your remedy before the referral court for higher compensation. This is the excess amount we have paid due to some clerical mistake. What has happened? Quickly I will submit before your lordship. When there was a calculation of a particular cell deed, what the clerks have committed the mistake, there are 5 plots, and the calculation they have made, the consideration amount for individual plots, the entire amount they have considered. Whereas the calculation, yes, my lord.
I think mistake is they calculated the amount under section 31, which they have added to the compensation amount.
Yes, my lord.
And paid. Now you realize that they are not entitled for 31 amount.
Now we have realized that this is the wrong, this is erroneous calculation. So according to the, because they have submitted a bond, indemnity bond.
Calculation on the ground that they are not entitled for 31 amount.
No. They are entitled. The calculation is wrong. Your lordship, I may be permitted to convince your honor, lordship, that the calculation is wrong.
sales statistics of village Kairapari. It has been mentioned. The sale deed is mentioned twice. So though they have two plots have been sold for 17 lakh, they treated as if each was sold. So when two plots were sold for 17 lakh, they treated as if each plot was sold for 17 lakh.
Yes, that is, yes, your lordship has rightly caught it. That is wrong. We are not saying that they are not entitled for compensation.
The amount is.
Yes, we have wrongly calculated, which was soon after.
Anyway, they are entitled to challenge it. You can't stop that for them. So who's for the petitioner?
Mr. Bhuya, he is suffering from COVID.
I know.
I understand. But so far as these writ petitions are, they have become infructuous because they have to, if at all they are so advised, they have to challenge the order of the collector again.
All right. You say counsel, Mr. Bhuya stated to be in some personal suffering from COVID-19. The court takes note of the fact that on 18th August 2021, the collector Cuttack has passed a reasoned order in terms of the direction issued by this court on 12th August 2021. It will be open to the petitioners, if agreed by that order, to file separate substantive proceedings in accordance with law. Just dispose it off. Yes.
My lord, another case may be tagged, Mr. Bhuya's case, that is not in the list, 19162 of 21. That may be called for the same matter. But it is not in the list, what I find. I don't know.
Yeah, I thought there was.
One 19162. Lordship may call for the file, that is similar matter, and order is also there in that case also. We have filed the order.
Mishra's matter is also here. Mr. Mishra's matter is also here.
34, that is, he has filed. Mr. Mishra is not here. I was just searching. Yes,
so kindly come.
Lordship may hear him also. The item number 34.
Yes, just take out item 34.
That can be also taken.
He's filed a fresh writ petition. So you filed a fresh writ petition. So we'll dispose of the earlier one. On the fresh petition, will issue notice.
Yes. Yes.
On the fresh petition, what the learned collector has done, he has recalculated, redetermined the market value as well as reviewed the compensation amount.
Correct.
That is why I say that that is not permissible under 2013 Act. I have taken a specific ground to that.
I will answer to this query of my learned senior. There is no chance of any recalculation.
You say the collector Cuttack has passed a reasoned order
under Annexure 3.
Yeah, on 18th August 2021. Pursuant to the order dated 10th August 2021, and that order has been challenged by the present petitioners in a substantive separate petition, WP Civil 26315 of 2021.
26315.
Accordingly, the present petition is disposed of in the above terms. Paragraph. In 26135 2021.
26315, my lord. 315.
315, correct. Notice Mr. Monty accepts notice on behalf of the opposite parties 1, 2, and 3.
Other opposite parties will be noticed.
Notice to. Actually, do we need to make them parties? I don't know.
Why they have? I don't know.
Why bank access bank or not?
Bank officers. Because my accounts have been freezed, my lord.
See, one thing we can do, that amount, we can ask them to keep it in a separate fixed deposit. People earn interest.
No, I have
we just ask them to keep it, whatever they're attaching from your account, that excess amount, let them keep it in a separate fixed deposit.
My lord, I have a suggestion subject to your lordship's acceptance. I have enough of property. I can place that.
No,
No, that all won't work.
sir.
You've got cash, sir.
Cash.
They paid you cash, they're entitled to recover that.
Yes, ma'am. 2
And
crores.
it was not
is
paid
money
long time
already
ago.
paid.
It was paid very recently to you.
All the, I have purchased materials, mine materials.
No. When was the amount paid to you in the first place?
I have given.
No, when was the amount paid to you in the first place? This excess amount, which they claim to be excess, when was it paid to you? When it was paid? Date on which it was paid, sir?
As per your lordship's query, I have submitted all my accounts to your lordship.
Sir, you just answer our query. When did your clients receive the amounts?
11 to 2021.
So this year only they received all these amounts?
Yes.
Yes, this year only.
Which month, which date?
He has invested it in purchasing materials.
Sir, you please answer step by step. You have to be patient with me. I'm not so sharp as you are. I just want to know the exact dates on which your clients received the compensation money.
11th February 2021.
11th February 2021, they received these amounts.
Yes.
Between 11th February and today, they have invested all the amounts.
And then not only that, we have given the.
My instruction is, when the refund notice was issued, immediately he has transferred a substantial amount, more than 60 lakhs, to his daughter's account, which is also seized. My lord, may kindly see, this is a government money, more than 2 crores.
Bank statements I have filed.
Yes, bank statement your lordship will verify. Your lordship can dispose of the matter, but so far as the attachment is concerned, if it is lifted. And one thing my instruction.
No, that anyway has been over. That repetition is over. With the interim model, this.
And there is no restriction for incoming, which my learned senior was very much apprehensive that money is not coming.
There are only 2 ways out. If you agree that whatever money you received, which they've calculated as excess, you put it in a fixed deposit.
Subject to
in the name of the collector. 1 minute. In the name of the collector, we will not allow him to encash it. You place that fixed deposit in the collector's name. We will say that without orders of the court, that amount will not be touched by anyone.
Yes, Miller.
That's the only way out, sir. Otherwise, I don't see a way out of this.
Miller, subject to your lordship's approval, once I have material.
To gather that amount, if you want to sell material, if you want to sell whatever you have invested, you do that. That is not their headache, nor will the court get into that.
I will deposit in favor of High Court.
No, why you in favor of High Court?
You just create a fixed deposit in the name of the collector of this excess amount in a nationalized bank, and it will keep earning interest. It will be subject to the outcome of the writ petition. If you succeed in the writ petition, you will get that entire amount together with the interest accrued. If you do not succeed, it will go to the collector.
Yes. Then your lordship may direct to be deposited in joint account of collector and my.
Why should it be joint? Why should it be joint?
Collector, the government officer, he is not a person.
So what is the exact excess amount?
Yes, my lord.
1 crore 92 lakhs.
1 crore
47,082.
All right. You say in the interim application, the excess amount determined by the collector to be payable by these petitioners works out to rupees
93 lakhs. 1 crore 92 lakhs 47,082 rupees. 197,247,082.
Where is the collector's order? Which page?
Collector's order.
That is
Annexure 3, my lord.
Give me the page number, please.
117.
16. You say the collector has, by the order dated 16th August
214 to 228,
determined the excess amount payable by these petitioners to be 1 crore 92 lakhs 47,082.
47,082.
Subject to the petitioners placing the above amount in a fixed deposit in the name of the
Collector
Katak in a nationalized bank, initially for a period of 1 year,
Obliged.
and depositing with the registrar of this court the original of the fixed deposit receipt with a photocopy thereof being provided to the collector Katak.
Or me also, I can.
Through counsel, through the learned AGA. The attachment of the accounts of the petitioners shall stand lifted.
Obliged.
By which time will you do it?
I will do it within 3 to 6 months.
3 to
6
months.
Months? No
Because my
question.
materials are there.
No question. Then let's not have any stay.
Where from I will get my lord?
No.
That amount
Please
is
don't take
like-
all this for granted, sir.
My lord,
Please don't take all this for granted. Your clients are not serious then.
My 7 crores of.
At the most, we'll give you 4 weeks time, at the most.
It will not be possible, my lord, because my.
If it is not, then there will be no, you say, counsel for the petitioner.
May I suggest one thing to my lord?
Yes.
If a lordship will permit.
Yes.
To the extent of this amount, the banks may be directed to.
There may not be that amount at all in the bank, sir.
No, that is there.
No. You think?
No. Yes, your lordship is correct.
What are you saying?
Yes, I am sorry. I am very, my staff is, they are saying that this is that. Yes,
My lord, I have purchased materials worth 7 crores.
Sir, your clients are not serious.
My lord?
Your clients are not serious.
Yes,
They
sir.
do not realize,
Serious.
they do not realize what the issue is.
And I undertake to comply with my.
Sir, maximum 4 weeks, not a day beyond 4 weeks. If you are able to do it within 4 weeks, you do it.
My lord, I
The
cannot
above
dispose it
fixed
of the
deposit
material
shall be
which
created
I-
within 4 weeks, failing which the attachment will not be lifted. That's it.
Obliged.
Replies be filed within 4 weeks, rejoinder within 4 weeks thereafter.
Well, I am for the OP number 5, my lord. My personal.
Yes.
My lord, at least 8 weeks time may kindly be given.
No, sir, 4 weeks, 4 weeks.
My lord, 6 weeks. 6 weeks, because it is not possible, my lord. 7 crores.
See, the sooner you do it, the attachment will lift. If it does not, if you do not do it, the attachment will not lift. So you better make up your mind.
My materials are lying in court.
All right, 6 weeks, your lordship.
All right, within 6 weeks. All right.
Well, I am for the OP number 5, 1 week.
That is already
My lord,
disposed of.
accounts may be decreased.
Only after you give that fixed deposit, original receipt in this court, only then, not otherwise. Yes.
My lord, I am unable to operate my account.
You have all your materials, sir.
My
You
lord,
have already purchased materials. That's what you are repeatedly telling us.
my lord, only
Yes.
if I draw money.
Within 6 months, you have spent away 1 crore 92 lakhs
My lord, may kindly.
buying materials.
Unless I draw money, how I will make a
You
deposit?
better make up your mind. If you think you have 1 crore 92 in your account, then straight away from that account, you create the fixed deposit. All right?
Yes, that I will do.
Do that, then that doesn't even require 6 weeks. It will straight away be done. We'll issue instruction to the bank. Is the balance in your accounts worth, do you have a balance of 1 crore 92 in your account?
No.
No.
Then, sir, don't argue contrary to yourself. Don't contradict yourself.
My materials are
So therefore, don't contradict yourself. If according to you, this 1 crore 92 is not in your account, it is in the form of material and something else.
Yes.
It is up to you to sell those materials, find this amount, produce the fixed deposit receipt, and then get that account lifted.
Unless I move, I will proceed.
Sir, how will you proceed? Because you have invested all this amount in some material, according to you.
Yes, sir.
You sell that material, they have not seized the material.
We have not seized.
It is lying at Visakhapatnam port.
Whatever, wherever it is lying, you have invested, you find out how you will record that money. It's not their headache.
Staff salary is to be paid.
Sir,
Your lordship may kindly bear with me.
Sir, please speak, first of all, speak into the mic. Sir, kindly speak into the mic.
At least defreeze the accounts for 6 weeks, my lord.
My lord, why?
Sir, there is nothing in your account according to you, correct?
70 lakhs is in my daughter's account.
So that 70 lakhs will you straight away put in an FD?
Hello?
Will that 70 lakhs will you straight away put in an FD?
Yes, I can put it.
When will you do it tomorrow?
Day after tomorrow.
Huh? All right. Tell us which accounts you have. Give us.
Day after tomorrow.
70 lakhs will put day after in the collector's. What is that balance? Is what? 1 crore?
30 lakhs around 1 crore.
After sale of the materials, the rest amount will be deposited.
No.
Within 6 weeks. Within 6 weeks.
No. The entire amount lying in the bank account in all the husband and wife and daughter is. They have.
What is the total in all your accounts?
Yes, that is what I was.
That is given under a memo, cover of a memo.
Mate copy देना Give me a copy.
Another restriction.
Another restriction that दिया है. वो देते आगोटा दिया है. 21103.
Can you give me a copy, sir? No, because now how can I react? How can I respond to your submission?
Names of the account holders are under column number 2.
So you want taken some loan and all that.
That is in remark column.
No. Everything you say debit, you're not saying credit.
Debit and credit. Total debit balance.
Do you know what debit balance means?
Yes. We have paid to bank. We have to pay to the bank.
So there is no balance then?
No, balance is individual account.
Individual account. Credit balance is there.
Saloni Tripathi, your lordship must see serial number 6 at the first page. 76 lakhs credit.
Sure.
The next line is 76 lakhs debit.
Yes.
What does that mean?
Against that we have taken a loan. FD deposit.
Sir, what amount do you have in your credit in your account? You tell us very simply.
We will liquidate that.
So what has happened? After they came to know about all these things that excess payment, immediately on the basis of the deposit, they have taken a fixed loan.
Earlier.
They have taken the loan. That is a deposit. So
they've actually
we are not
diverted the entire amount into investments.
Exactly. That is also reflected in the order.
That's why your attachment is useless. Your attachment is useless. There's nothing in the account.
No, still there is a huge amount in the lying in the account.
Which amount? You tell us.
Husband, wife, and daughter.
Statement has been given.
In the husband's account.
What are you reading? What are you reading?
This is the official copy for the husband account. 15,85,773 in Subhas Tripathi.
Where are you reading, sir?
No.
They are supposed to give the bank statement today.
Yes, we have given. We have given.
Under the statement.
Under the statement.
Under the statement, bank statement.
As on date, both husband and wife around 19 lakhs.
You take out from this paper book what you given. That statement is all confusing, sir. Totally confusing.
This is a self bank statement.
I have attached the bank statements also.
Put the bank statement.
Neither of us is an auditor. You tell us what is the plus credit balance in each of the accounts. Don't make us go round in circles.
Please.
In first phase, it belongs to Axis Bank. Number 1, Subhra Tripathi, petition number 2, credit balance is only 141.06. The second account belongs to petition number 1.
Where from you are reading?
From the statement manual. And all the bank statements in the original has been attached.
If you add up all the credit figures and add up all the debit figures, what is the balance?
Lastly, it is summary is there. In the first page, debit figure is 2 crores.
So debit figure means what? What does debit figure mean?
Debit figure means you have to pay to bank.
Which means you have any amount you obviously do not have.
In Axis Bank, with respect to serial number 6, Solon Tripathi, the major debtor, there is a credit balance of 76 lakhs.
But look at the next column, the same account. Next line, the same account.
Which we can liquidate. 80 lakhs FD is there. We will deposit 70 lakhs. We will keep 10 lakhs for day-to-day business management, my lord. Because we have to move some places to sell the material, negotiate with the customers. Otherwise, everything will be transferred, my lord.
You see the next
Everything will be
column
transferred. Money is unable to purchase medicine, pour fuel in his
You
vehicle.
are not answering, Mr.
My lord, I want
You are not answering the question. You come to column 7. Soloni Tripathi, the credit is 76 lakhs, and then loan sanctioned against 10 numbers of FD.
No, because 80 lakhs FD is there. Against 80 lakhs, there is a debit balance of 76 lakhs. We will liquidate that FD and we will get 76 lakhs into our account, credit balance. That's the only possibilities with us. And with respect to another accounts, only credit balance would available with Subhash Tripathi 5 lakhs 40,000 because bank has honored the GST payment. Otherwise, without payment of the GST amount, he cannot sell the material. The GST certificate will be.
You kindly listen now. Kindly listen.
Sir, my lord.
The excess payment which the collector has determined,
my lord,
is 1 crore 92 lakhs.
My lord.
You are now saying out of that 1 crore 92, an extent of 76 lakhs, you are prepared to create an FD tomorrow itself in favor of the collector. Correct?
Therefore, it was 70 lakhs, my lord.
So the balance will still work out to 1 crore 16 lakhs.
16.
Or no, 1 crore.
Yes, 16.
1 crore 16 lakhs. 16 lakhs
16 lakhs.
82 rupees.
16 lakhs some odd.
So how soon will you make up for that 1 crore 16 lakhs?
My lord, we have given another memo just below that.
No, you answer how we can part.
My lord, 15,000 metric tons of iron ore fines. Just below that by statement.
See, the collector, no point in depositing 15 crores of iron fines with the collector. All right. He doesn't want iron fines.
My lord, kindly listen. It is worth about 5,000 metric tons, 7 crore 50,000 material.
Sir, that was of no concern. How soon?
It is very less, my lord.
Kindly listen.
Another 1 crore if you will sell now. So he has to take some time. He is negotiating with the parties.
See, the more time you take to sell those iron fines, the more the attachment will continue. Be very clear in your mind.
No,
right?
My lord, that
the day you sell those iron fines and recover that 1 crore or something, the attachment will be lifted. Should I record a statement that 76 lakhs tomorrow you will create the FD?
Day after tomorrow.
Day after.
All right.
Yes.
You see, relying on certain bank statements based on record. Petition Civil 21103 of 2021. Counsel for the petitioners assures the court that on or before 4th September 2021 by 5 p.m. a sum of rupees 76 lakhs will be
70 lakhs, my lord.
76.
Another 6 lakhs will be moved and we will pour fuel and we will negotiate with the
76
parties.
lakhs.
Otherwise, no cash is there, my lord. Kindly visualize.
No, we are not.
You are not allowed to approve the bank.
Following at all what you say.
So he thinks that your lordship is defreezing the account.
Kindly visualize. Otherwise, he cannot move. He cannot even arrange his day-to-day expenses.
You have created a mess for yourself.
Yes.
No, my lord. Now, please visualize. Kindly visualize, my lord.
Correct. You have just created a huge mess for yourself.
Yes.
We're not lifting the, let's be very clear, till you're able to create an FD for 1 crore 92 lakhs, we're not lifting the attachment.
Obliged.
As simple as that.
No, my lord, whatever order you ask.
If whatever is the money in the account, if you still want to convert it into FDs in the name of the collector, we permit you to do it. To that extent, the attachment has to be lifted to permit you to do that.
Maybe 76 lakhs.
76 lakhs in name of the collector, Katak, in a fixed deposit with a nationalized bank. To the above extent, the attachment of Axis Bank account number
Account number 9210100
9210100233 50282 in the name of Saloni Tripathi shall stand lifted. It is however made clear that this savings account with the, which bank is this?
Other banks.
Other banks.
No. This account must be with one bank. This account number of which bank is this?
It is Axis Bank.
Axis Bank.
Axis Bank.
Open number 5,
Yeah.
maybe direct.
Will be lifted only for the above purpose and not for any other purpose. The original of the FDR receipt, which should be in a nationalized bank, will be placed with the registrar of this court.
Obliged.
And will be initially for a period of 1 year and will be kept renewed until further orders. A photocopy of the said FDR receipt will be provided to the collector through the learned AG. Paragraph. Counsel the petitioners says that they need at least 6 weeks' time to create an FDR for the balance sum. That is 1 crore 92 whatever minus 76 lakhs.
Within 6 weeks.
The sooner the petitioners are able to recover the balance sum, the attachment of the court can consider lifting the attachment of their bank account. List on 9th November.
Obliged.
I am for the OP number 5, 1 month time available for counter filing the counter.
That is disposed of. He is appearing for the bank in the first matter, which is your lordship.
That is over.
That is
first
over.
matter is over. In this, Mr. Bhuyan's matter, should be 6.
Yes, Mr. Sahu, Ms. Sahu, she was
My
appearing.
lord. My lord.
So you'll have to file fresh writ petitions anyway, Ms. Sahu. All right.
Because in the counter, the collector has filed the press order. In the counter, they have filed, the collector has passed the press order. You have to challenge that order. So in that view, observing that, we are disposing of the writ petition.
Yes. The writ petition stands disposed of in the above terms. All right.
My bank accounts are defreezed or other bank accounts are not defreezed.
Not defreezed.
It will be considered after I make the deposit.
Correct.
Urgent certified copy may kindly.
Urgent certificate. Item
And the next
14,
date may kindly be please.
9th November.
9th November.
If you do it earlier, you file an IA, will advance the date.
Yes, my lord. If they deposit the entire any date.
The sooner, that's why we have observed, the sooner you do, the sooner.
And I am
the attachment
trying to
will-
file the counter within 1 week or 2 weeks.
Can I make a prayer to call it on 9th September?
No.
September.
If you recover, if you are able to find the money earlier, you just file an IA. All right, it will automatically come up earlier. Item 14.
For the balance amount, if he deposits, then any day your lordship can.
Exactly.
May it please your lordship. Item number 14, my lord. In this case, my lord, petitioner challenges the order of dismissal dated 3/6/2018 and the Honorable Tribunal Labour Court passed the order on 12/7/2018 on the ground there is a delay, my lord. But as a matter of fact, there is no question of delay. Within 1 month, I have challenged the order under annexure 3, my lord. The order of dismissal is under annexure 3 at page 16, my lord. And immediately thereafter, I filed the challenged that order under annexure 5, 12/7/2018. And only solely on the ground of a delay, Land Tribunal has dismissed this case, my lord.
No, let's get the dates properly. 12/12/2009, you were dismissed from service, correct?
That is not correct, my lord, because I am continuing in service. Your lordship may turn to page 8, my lord. As an in-service candidate, I was also issued a letter for selection. That is at page 31, my lord, annexure 8. Mr. P.S. Tripathi, present petitioner, recruitment of in-service candidates from the existing staffs, my lord. And I am continuing till 2018, my lord. And as per the Limitation Act, my lord, section 2A(3), my lord.
One minute. Do you have a copy of this ID case number 40 of 2018, which you filed? Where is that?
ID case, my lord. The order is, I have annexed, my lord.
Not the order, sir.
A petition copy, my lord.
Yes.
That is not available.
It's not available with you. You better place that before us.
My lord, may I
We want to see, we want to see what you have said there.
No, I think you have annexed statement of claim.
Yes, my lord.
Annexure 6.
Statement of claim I have submitted, my lord. That is under annexure, annexure 5, my lord, at page 22.
ID case number 40.
Yes, my lord. That is in the year 2018, my lord. But the London Labour Court rejected on the ground of delay only.
No, 1 minute. Up to para 1 of that.
Yes, my lord. Para 1 of judgment, my lord.
Petition,
my lord, yes. That I have been working as office assistant for the period from 5/7/1999 to 11.
Come to page 25, annexure 6, the claim petition.
My
statement of claim.
Yes. That the second party workman had been working as office assistant by the first party management for the period from 5/7/1999 to 11/12/2009, near about 10 years.
So 1 minute. So even according to you, you were working only till 11/12/2009.
Thereafter also I am continuing, my lord.
No, where have you said that?
And thereafter,
where have you said that in this claim petition?
On subsequent paragraphs, I have mentioned, my lord, without any stigma, and my last wage was fixed at.
Don't run. 1 minute, please.
In para 2, my lord, I have mentioned.
What have you mentioned?
In para 2, my lord, but on suddenly, first party management has changed working hour without.
That is very different.
So, everything is mentioned.
Sir.
My lord.
This is very different from saying that after 11/12/2009, you continued in service. Where have you said that?
That is at annexure 8, my lord.
No, where have you said in this petition?
In petition, my lord, yes. But on so the first party changes also, that the second party workman requested before the management under para 3, my
No,
lord.
Mr. Pradhan, you have not stated. Your case is that you have been terminated in December 2009.
Retrospectively, my lord.
Thereafter, again, you have said also that thereafter.
But the order I have challenged, that is of 2018, my lord. And as per the Limitation Act, within 3 years I can challenge. That is clause section.
Now come to para 8 at page 27.
Yes, ma'am. Eight. Second party workman further stated that aforesaid management has issued the dismissal order dated 12/12/2009 and communicated on 3/6/2018 without obtaining approval under section 33A.
Somebody don't communicate dismissal order for 6 years.
Dismissal order, my lord, on 3/6/2018, my lord. So may I pray, my lord?
The statements are all unbelievable, totally unbelievable. You have not said anywhere that after 2009 you were working.
That is under annexure 8, my lord.
That can't be an annexure, please. In your claim petition before the labor court, you are expected to come out with full facts, correct?
May I pray, my lord? Your lordship may adjourn the matter for at least 1 week.
No, why, Mr. Pradhan, why you are seeking adjournment?
Otherwise, my lord, may I pray, my lord? Since the limitation is 3 years, from the date of order, I have challenged within that period.
How is it challenged?
May the matter be remanded, my lord?
No, how you challenged in 2018?
18.
Order was in 2009, after 9 years.
No, my lord. 2018 order, they have retrospectively dismissed me.
That is your case. That is your
But the order is
case.
2018, my lord.
No, that is your case.
Your lordship turn to page annexure 1, my lord.
How do you substantiate that
I have substantiated,
2018
my lord.
only received?
Because
How
I
do
am
you
serving
substantiate?
and all these documents I have annexed onto annexure 8 series, my lord, which proves that I am working, my lord. Perhaps he has not mentioned in his.
Not covered anywhere that you are working, please. You have not made any government anywhere that you've been working.
That perhaps he has wrongly not mentioned.
What is that? No question wrongly not mentioned.
In petition, I have mentioned, my lord.
Not in the petition before us. In the petition before the labor court.
Yes, my lord.
Where have you pleaded that after 2009, you were continuously working?
Then your lordship may adjourn at least 2 days or.
How can you suddenly, what adjournment will not introduce paragraphs into your claim petition?
That documents I have annexed and I have avowed that I am working till 2018.
You have not avowed anywhere that you are working till
In that
2018.
petition I have not mentioned.
Ah.
My client has not mentioned.
Ah.
But in the present lead petition I have mentioned and I have a.
We are now, you are challenging the labor court order, correct?
File documents also, my lord. In some.
You are challenging an order.
The case record is put up for
No,
examination.
no, you don't need to read that. In fact, your prayer also, just come to the prayer clause at page 28.
Yes. Yes.
Read the prayer clause.
2009.
Prayer clause. It's okay.
2009. But the order which has been passed by the.
No, no, so where, the question repeatedly we are asking you is, where have you avowed in your petition before the labor court that you were working continuously after 12/12/2009?
That perhaps not mentioned, my lord.
All right. You see, the challenge in the present petition is to an order dated 16th October 2019 passed by the Labour Court, rejecting the petitioner's ID case number 40 of 2018, filed under section 2, capital A bracket 2 of the Industrial Disputes Act 1947, seeking reinstatement in employment of the opposite party number 1 with full back wages with effect from 12/12/2009. Paragraph. From a copy of the aforementioned ID case 40 of 2018, which has been enclosed as Annexure 6 to the present petition, it is clear that throughout the petitioner has stated that he was working with the opposite party number 1 till 12/12/2009 when he was dismissed. In fact, the prayer clause reads as under. Correct. In the 18th order, the learned Labour Court has on a reading of section 2 capital A bracket 3 of the ID Act, read with section 2A bracket 2 thereof, come to the conclusion that the industrial dispute raised thereunder has to be, the industrial dispute thereunder has to be raised before the expiry of 3 years from the date of discharge, dismissal, termination of service. With the petition having been filed only on 31st August 2018, clearly it was time barred. Paragraph. Counsel for the petitioner sought to contend that the dismissal order was communicated to the petitioner only on 3rd June 2018. However, there is no document to substantiate this whatsoever. In that view of the matter, the Labour Court cannot be faulted for rejecting the petitioner's application on the ground of limitation. The petition is accordingly dismissed.
May I pray, my lord, I will approach the authority. They will consider sympathy.
No.
As well as the constitutional validity of section 16 to C of the OGST and CGST Act, it is so far as the same imposes unreasonable burden on the purchaser to satisfy the condition of payment of tax by the supplier to avail input tax credit. Because your lordship will find, because Annexure 3, I have submitted all documents to the effect that all the supply is affected and supported by tax invoice. Tax is charged, and I have paid all taxes in respect of the invoice to the seller. And the seller, what he has done, are saying that because he has not paid tax, so you have to now, the claim of credit, input tax credit is wrong. Your lordship have admitted similar writ petition. You might not may kindly travel to page 36. Page 36, paragraph 19. In the Sri Govind Allies Private Limited versus Union of India, PC 16242/2021. This matter, your lordship kindly bear with for a moment, because apart from that, all other high courts in next previous paragraph they have also admitted.
Copy of the order.
Copy of the order,
Your lordship,
must be available to Lord and Friend.
Your lordship, in that case, your lordship has issued notice, and I had accepted notice on behalf of the GST department. And so far as the interim application is concerned, your lordship, has passed the order that all actions taken in the meanwhile subject to the outcome of the present writ petition, and the application has been disposed of. Now, your lordship, this case, Annexure 6 and Annexure 7, your lordship, are the so-called notice issued by the GST department. So let my Lord and Senior comply to those notices during pendency of this writ petition. Your lordship, so far as the constitutional validity is concerned, your lordship may admit this writ petition being similar to that writ petition.
The argument of my Lord and Friend can be verified. My lords may kindly see for a moment, Millers, Annexure 4. That will tell you everything, Millers. All things are not same. Annexure 4, my lords may kindly see at page 49, Millers.
The same thing, your lordship, the same thing my Lord and Senior can place before the
my friend will interrupt in course of argument.
Sorry, I'm
helpless. If my friend will interrupt always in course of argument, I'm sorry for this. Plus page 49, Annexure 4 minus. For not members paying tax and not filing return, which has troubled me for availing credit bills, the proper officer has already assessed the selling dealer. Your lordship will kindly see the assessment order which I have annexed. This assessment order pertains to my supplier bills. Under section 62, minors, yes. And this period covered is May 19 to September 19. And next page 52, your lordship may kindly see.
So, Mr. Sahu, I think what he's trying to point out is that Annexure 6 is the show cause notice, correct?
Minors.
So you have to reply anyway to the show cause notice.
Minors.
We will say that whatever order is passed after your reply will be subject to the outcome of this writ petition. That's it.
May I submit, your lordship only say because there will be double payment of tax. They have already realized from a supplier, and again they are demanding from me. My lords may kindly be subject to your lordship's approval. All final order may be subject to result of writ petition. Without leave of the court, no final order without leave of your lordship. At least to that extent,
if you pass the final order, it will anyway be subject to the outcome.
Sorry, minutes.
If they pass a final order on the show cause notice, it will anyway be subject to the outcome of the writ petition.
That's what will happen. They will enforce payment then, because they have already. They
don't know what final order will pass.
No. Annexure 4, your lordship have seen. They have already assessed my supplier.
No, Mr. Sahu, my thing is, you will draw their attention in your reply to the show cause notice to that Annexure 4.
Absolutely.
We cannot predict whether they will agree with you or disagree. So it's only if they pass an adverse order, then the question will cross the bridge when you come to it.
Your lordship may permit them to approach your lordship, grant liberty to me.
Yes, obviously. You say notice, Mr. accepts notice. Reply will file within 4 weeks.
On behalf of opposite party number 3 and 4, I am accepting. Opposite party number 1 is Union of India, 2 is the state government.
Mr. Pari, yes.
Mr. Pari is there. All right.
Yes.
You see, it is pointed out that a show cause notice has been issued on 12th May 2021 to the petitioner, Annexure 6. Mr. Sahu states that reply to the show cause notice will be filed with the petitioner not later than 4th October 2021.
subject to complying with the above assurance, any order passed on the said show cause notice would be subject to the outcome of the present petition. If such order is adverse to the petitioner, it will be open to the petitioner to apply to the court for directions.
But why you made the law secretary as a party? No, why?
Because your lordship is correct because normally
Yes. I don't know. Opposite party number 2 is not a necessary party. You say opposite party number 2 is deleted from the array of parties. The consolidated memo of parties be filed within 2 weeks. So Mr. Mishra accepts for 3 and 4 bracket renumbered as 2 and 3, and Mr. Party for opposite party number 1. All right.
Obliged, Julius. Greatly obliged.
Item 16.
I am appearing for the state matters. Some defect has been shown.
Here, my lord, the petitioner has spread for a direction to the opposite party number 2 to pay higher compensation to the petitioner, my lord.
But you already approached under section 64.
My lord, already approached the year 2016, my lord. They have not followed the act of 2013, my lord, and they have the land of the petitioner.
No. You approached me, what? You filed an application, petition. What did you file?
I filed on, my lord, your lordship will find that at page 30, my lord. 8 page 2016. Page 31.
51 is what? 61 or 51?
31, my lord. 31. Hence,
this is 61.
My lord.
Is this application under section 64?
My lord. Hence, I request you to kindly refer it to the appropriate authority.
This received with signature is whose signature?
Received signature S. Dora.
Who's S. Dora?
This is the land acquisition officer, my lord. He received. Your lordship will find the collector come land acquisition officer DM Burger, my lord.
It's more than 4 years ago.
What has happened, my lord?
Insurance has not been made.
No, my insurance has not been made, and your lordship will find, my lord. This is a case, my lord, where the land of the petitioner was acquired without following the act of 2013, my lord. They have the 1 acre and 22 decimals of the petitioner land acquired, my lord. They have 15,000 per decimal, my lord. Whereas, my lord, for the other land oustages, they have paid more than 1 per decimals, my lord. I have also annexed at annex of 40 and 6.
No. In page 31, you say you have executed the sale deed in favor of the engineer.
Yes,
on 11/11/2016.
Yes, my lord. Your lordship will find in the next 3, my lord, they have to promise to pay higher valuation of compensation, my lord, at page 36. Number 6. मूल्य परवर्ती डिस्कसी मीटिंग निर्धारण करा गले हमें संपादनकारी परिवर्तित मूल्य को हकदार हेबु DCC meeting has already been held. Other these have already.
No, you've already received. Let's be clear, Mr. Sahu. You've received 16,95,000 already, correct?
Yes, ma'am.
So you're actually claiming only higher compensation.
Yes, ma'am.
For which you have to move under 64.
Yes,
ma'am. Under 64.
That has to be during a period of limitation, madam. So that is not clear whether he has moved within.
No. He says he has filed this on 8/12/2016. The sale date is 11/11. He's filed his application on 8/12.
11/12.
So that's not time barred.
Thereafter, also, my lord, what has happened, my lord, in the sale deed itself, my lord, they have promised to pay the higher compensation amount, my lord.
No. After this 8/12/2016, what were you doing?
Thereafter, also, my lord, they registered another sale deed, my lord, in 2018 for Gharawari Kisam of land, my lord. Your lordship should find that Annex of 4 in 2008. Again, they said that they will pay the higher compensation amount in that cell deed also, my lord.
That is in respect to another.
Have you filed after that anything?
Yes, my lord. Annexure 7, your lordship will kindly bear with me. Annexure 7, page 56, my lord. That is the representation dated to November 2020.
Ms. Patnaik, should we just pass a time-bound direction?
For disposing of the representation, my lord?
Yes, not representation, you have to make a reference.
Yes, my lord. Or if your lordship want, I can get back with her.
He should have, but he never told him anything. All right, you can find out if they've received this and what they've done.
Yes, my lord.
The counsel the petitioners points out that there have been 2 applications given to the collector Bargad, one on 11/12/2016 and the other on 2/12/2020, bracket annexure 7, seeking reference of the claim for higher compensation. Stop. According to him, the petitioners have not heard anything from the collector. The earlier one you say on 8/12/2016, not 11, 8/12/2016, bracket annexure 3. Ms. Patnaik states that she'll seek instructions on the present status of the aforementioned 2 applications at her request list on 25th October.
Please, my lord.
Item 17.
May I please, my lords? This is with regard to encroachment of grazing ground of the villagers, my lords, at Mongoli, my lords.
Who are the encroachers?
My lords.
Who are the?
Miscreants of the localities and land brokers, that
they have names.
Occupants cannot be.
Do you have names? Do you have names for them?
My lords.
Do they have names, those encroachers?
Encroacher ମାନଙ୍କର ନାଁ ଜାଣିଛନ୍ତି?
The miscreants and land brokers, if the name of the.
No, you get the names of the encroachers first.
1 to 2 time, my lords.
No. You first, you are even a representation, you have not named the encroachers. You have to first find the names, then make a representation setting out their names.
Representation has been submitted by the annexure.
Have you named the encroachers in the representation?
There is apprehension of danger to life.
You withdraw and find out the name of the encroachers.
Okay.
Counsel for the petitioner seeks leave to withdraw this petition with liberty to file a fresh representation to the authorities naming the encroachers, naming the alleged encroachers whose removal the petitioners are seeking. And after following up on that representation to seek appropriate remedies in accordance with law. Dismisses withdrawn with liberty is paid for.
Item 18.
May I please, Lordship? Lordship, the petitioner have agreed due to inaction of opposite parties in laying the public road half constructed since long under Pradhan Mantri Grama Sadak Yojana in time period. Lordship, the fact of the case, Annexure 1 is the work order of the project work. Duration of time period to complete the 28/8/2019 to 27/5/2020. Let's have a glance. Annexure 2 is the incomplete road, the said road till now. Let's see the near about 100 meters left out in a particular area. And
all right, your representation is there. All right. The petitioner's representation dated 5th April 2021.
OP3.
To the
executive engineer, rural works division, bracket opposite party number 3, shall be examined, and after hearing the petitioners as well as opposite party number 5, appropriate orders shall be issued by the executive engineer not later than 1st November 2021, and copies of the order shall be made available to the parties not later than 8th November 2021. The petition is disposed of.
For admission item 19.
In this case, the limited grievance of this petitioner is that whether illegitimate child has a right to get the compensation given by the railway and which was rejected by the special land acquisition officer opposite part number 3 when he has filed the objection on Annex 4 page 16. Following part. Page 16. When he filed the objection, at the 14/12/2000.
So for apportionment of the compensation, you do not have any statutory remedy.
Hello?
For apportionment of the compensation amount, you do not have any statutory remedy.
But he has filed the objection petition before the special land acquisition officers, and land acquisition officers has taken.
No, they filed a detailed reply. It's not filed a rejoinder. He's not the legal heir of Girija Shankar Badai. Never produced a legal heir certificate. Come to para 8 of the counter. The petitioner complains of non-disbursement of compensation, of his share of the compensation amount pursuant to the acquisition of the land in question. The petitioner claims to be a legal representative of late Gauri Badai,
Kindly annex of 4, page 16.
who in turn had inherited the land in question from her deceased father, Sri Damodar Badai. Paragraph. In the counter affidavit filed on behalf of the opposite parties, it is categorically stated in para 8 that the petitioner is not the legal heir of the late Girija Shankar Badai and never produced any legal heir certificate in support of such a claim. He was afforded enough opportunities by opposite party number 3 to produce a legal heir certificate at the stage of objection under section 6(9)(3) of the LA Act, and he failed to do so. He only submitted a voter ID card, which obviously was not conclusive proof that he was the heir of the late Girija Shankar Badai. Paragraph. The petitioner has not filed any rejoinder to dispute the above governments in the counter.
Kindly peruse the annex of 4, page 16. That is the inquiry has made, and they had stated that he is the concubine, the child. The peruse all the inquiry reports reveals that. Page 16, my lord.
Yes.
The perused all the inquiry reports reveal that the Susnanda Badai, the son of concubine of Girija Shankar Badai, who is residing in village. And after that also, so they have
no legal heir certificate has been submitted.
No, my lord, when they give the 7 days time to file the legal heir certificate, it is not possible to.
Even now you have not produced it.
My lord?
Even then you have not produced it.
Well, the illegitimate child has the right to the
No, but you have to produce a certificate, legal certificate.
My lord, they have given a chance to some because since he has to be file the legal certificate within 7 days, they have given.
No, my lord, 1 month time was given. You
My
lordship
lord,
will kindly
my
please.
lord,
You not filed a rejoinder.
My lord,
Yes.
my lord, page 14, my lord, can see.
Yes.
My lord, see same page 17. The file a regular certificate within 7 days from the competent authority. Is it possible to my lord to produce a regular certificate within 7 days?
Not been produced subsequently.
It is not possible to file a legal certificate within 7 days.
All right. The petitions according to this. Sorry, please. Yes.
My lord, may
You can't be after. Item number 20.
May I please? This is challenge of the labor court award, that is a reinstatement. And I have talked with my friend. You are both agreeable to, you will agree to compensation. Some compensation. In lieu of compensation, you are willing to agree, accept some compensation, in lieu of reinstatement. Malum decide some amount.
How many years has he worked?
Malad,
How many years have you worked?
Myla? 55 years.
55 years.
Now 55 years.
60
How many years you have worked?
13 years.
13 years.
Yes, ma'am.
And he has received 17B
88
for all
to-
the last 8 years.
17B you are receiving.
My lord. That is a mere amount of 1200 only.
What was that last wages?
Yes.
You are daily wager. And in the meantime, he must have accepted some other work. I presume.
No, ma'am.
Last 8 years. We are paying 17B nonetheless. I don't decide some amount.
How many years did you work? 13 years.
What is this? Case law.
Yes, 88 to 2001.
Right. It's not clear what is remuneration is. What is he earning in that company?
What was your remuneration per month during your service?
You are daily wager.
Daily wager.
So how much were you earning?
He was receiving 1200 an odd at the time of retirement. 2001.
How much?
Yes, 12.
Per month.
1275 per month. 30 days. On daily wage basis. That we are paying.
It's 1.5 lakhs. Even 10 years, I just said it. $14,400. 15,000. 15,000. 14,000. 12 into 12. 40.
What amount you propose?
I propose 2 lakhs.
2
Your
lakhs.
lordship, 4 to 5 lakhs, your lordship, any amount. Now the minimum of this is, no, no, minimum is
4 lakhs is fine.
4 lakhs?
Yes.
Well, that is almost entire amount for the back wages.
Yeah, in 2021, petition has been pending for 8 years.
Malad, he has
Petition has
already
been pending for 8 years, the litigation expenses.
8 years he received 17B all the
Means,
years.
as per you, how much you would have paid in 2001?
2001. 2000 received 1200. And he has on labor code has awarded 28,000 for back wages. So
No,
only
no.
on the
As per
on the
you,
labor code award 25,000 for the back
no,
wages.
as per you, in view of the compromise, if it had been in the year 2001, how much amount you would have paid to him?
No amount. Only 28,000.
No, no. Back wages with
28,000
reinstatement,
back wages.
28,000 back
And
wages.
work. You are paying idleness for last 8 years. 13 to 21 we have already paid. 8 years we have paid.
Mr. Patnaik,
Again.
now you are ready to compromise.
Again, both of us.
Both of you are ready. So had it been done in 2001, what would be the amount?
And if you add interest to that for the last 20 years,
Not 20 years, only 88 years.
2001 to now it was 21.
Only labor court has covered the period of packages up to 12 from 2005. Here, after the court, 10 years for last 10 years. What would be the interest?
I will premium on let it be 3 lakhs.
3 lakhs. 3.5 lakhs.
All right.
3 lakhs will be done.
Both parties agree that they have agreed to settle their disputes, and the respondent has instructed the counsel for the respondent to inform the court that he is agreeable to receive rupees 3.5 lakhs as compensation, as full and final compensation payment in lieu of all his claims arising from the impugned award of the Labour Court. The aforementioned amount will now be paid by the management to the workman on or before 1st November 2021. The petition is disposed of.
Item 21.
I am appearing for the opposite party number 3 workman, madam.
May I please, your lordship?
Yes.
Here, this is an ex parte award. For the reason, your lordship may kind turn to page 8, first page of the award. The first party management has been shown as Executive Engineer Noraj Barrage Division number 1, and this reference was registered in the year 2002. Prior to that, the address of the management has got changed, that I have stated in paragraph 5.
You have been set ex parte.
Yes, madam. For this reason only, because of change of name, no notice was sought.
No. You have been set ex parte.
Yes, madam.
Thereafter, have you filed any petition to setting aside this award?
No, we received the intimation for the first time after March, after the award has been published. That is at page, you lordship may kind of to page 7, page 16. From the employees letter of the employees union, we came to know that such an award has been passed. But since the award has already been published, so there is no scope of filing of any application for review or recall of the order.
No, so there was no stay of the award.
No, madam, no stay.
So it's been implemented now.
No, I don't have any instruction also.
Why? You should know.
Madam, I am for the opposite party number 3, madam.
No, what is your status now? Regarding implementation of the award?
Not implemented, madam, till today.
Not implemented?
No.
You did not move for implementation.
You did not file any execution case?
No, madam.
Why?
They have challenged before the honorable court.
If they challenge, you should not file.
Yes, madam.
Is that the law?
No.
What prevented you from executing the award?
Not filed the execution case by the workman, madam.
No, for 8 years. There's no stay of your, for 10 years now actually. The award is 26/11/2011.
10 years.
For 10 years, how can you, with no stay of the award, why did you not move to execute it?
And there was also direction for reinstatement.
Reinstatement. You've deprived your clients of reinstatement and full back wages.
Yes, ma'am.
You're saying yes. Don't you think it's strange?
But not filed.
What are you saying?
Union carry out the case. Madam, the workman are the poor person and
he has won the matter, please. That poor man has won the award. He has won something. Despite succeeding because of your inaction, he is not getting anything.
Execution not filed, madam.
So shocking. It's really unfortunate. So even if you dismiss the writ petition today, you will do nothing.
I have filed execution.
Mr. Mudli, I think they're all subsidizing the government like this. By sheer inaction. Bad enough that you do not take action, they are one step better than you.
Unbelievable, really unbelievable. How are you depriving such poor laborers like this? What right do people have? I don't know. What is this going on? For 10 years.
10 years is not doing it. And your client is not coming to you.
My lord,
Your client is not coming to you.
my client is with me. But I have not filed the.
But you do not have any advice to give him.
Advised, but
There is no stay past this of the award, and you have done nothing. For 10 years. What is the reason for the delay? Now that Mr. Mudli,
Yes, my
what is berate him for not moving execution? What is your explanation for delay now?
And so far as execution or implementation of his contract, that I don't have any instruction with
No,
that.
he is himself saying he was so kind generous about your move. So not only did you not file anything till you filed, even after you filed, he did not do anything. So how did you suddenly wake up one day to file this writ petition?
No, your Lordship, page 16, that is the information we received from the employees union regarding passing of the present award. So thereafter the matter was processed, and after obtaining approval, they contacted our office. Accordingly, we have filed the writ petition.
So they informed you in June 2012.
Yes, 18/6/2012.
When did you file this petition?
That was filed on 24/9/2013.
How soon, Mr. Mudli? Very quickly?
Yes, that we have explained the delay. Paragraph 6, 7, and 8 we have explained so far as the delay is concerned.
Let's see, what is the explanation?
Paragraph 6, that on the matter stood that the petitioner received the letter dated 18/6/12 of the General Secretary so Employees Union along with the award dated 26/11/2011.
Nothing, absolutely nothing. All writing to each other all the time. That's all. Yes. You say this is an instance of extreme slovenliness on all sides. Stop. The executive engineer Naraj Barrage Division, now renamed as Drainage Division Cuttack, has filed this petition on 24th September 2013, challenging an ex parte award dated 26 November 2011, passed by the Labour Court, Bhubaneswar, in favor of the opposite party workmen, holding that the refusal of employment to them was neither legal nor justified, and directing that they should be reinstated with full back wages. Stop. According to the petitioner, he became aware of the above award only when the Employees Union wrote to him on 18th June 2012 asking for its implementation. Stop. Strangely, till date, no execution proceedings have been filed for implementation of the award, despite the fact that in the present petition, no interim order staying the implementation of the award was ever passed by this court. Paragraph. In response to a question about the delay in filing the present petition, Mr. Mudli, Learned AG, appearing to the petitioner, drew the attention of the court to paras 7 and 8, which read as under. Paragraph. The explanation offered in the above paragraphs is wholly unconvincing.
and unsatisfactory. Stop. By the inaction of the petitioners, they've defeated the implementation of the award, and this is compounded by the fact that even counsel for the respondents did not think it fit to file any execution proceedings till date. Paragraph. The court is not satisfied that any satisfactory explanation has been offered with the petitioner for the delay in approaching the court for relief. The petition is dismissed on the ground of laches.
Item 22.
May I please, Your Lordship? This is the legitimate expectation of a Balwadi teacher who has been subsequently appointed as the Anganwadi teacher, Lordship. In this case, Lordship, basing on a subsequent circular of the government, they have asked me when I was continuing as the Anganwadi teacher, Lordship. They have filed the counter. I have not received the counter copy, Lordship. The opposite partner 1, 2, 3, they have filed the counter.
Let me law by Lord, I'll serve a copy on him. Okay. You want, but to serve a copy on you.
Lordship, in the meantime, opposite partner 4, who is continuing as the Anganwadi teacher on the order of the ADM, I have replaced by the opposite partner 4. Lordship, may kindly issue the notice to the opposite OP number 4. I have filed the requisition.
This is a 2014 writ appeal.
No, I am appearing for OP number 4, my lord. I have filed the Vakalatnama in this case, my lord.
He has approached this honorable court with an unclean hand, my lord. Lordship, may kindly come to page 2 of my counter affidavit, paragraph 4.
Lordship, I don't have the copy. Let them supply your Lordship on this matter.
Yes, my lord. I'll supply a copy, my lord.
No, but anyway, you tell us what is wrong with the impugned order.
Lordship, in this case, I was continuing as the Balwadi teacher. During that time, the circular was the Balwadi teacher, when there will be this center will be converted to the Anganwadi center, they will be joined as the Anganwadi center. But subsequently, there was a notification of the government that has been issued by the Women and Child Development Department. What they have on their circular, what they have issued, that is on after my joining as a teacher in the Balwadi center, Lordship. Lordship, that I do not know whether that has been I have annexed or not. Can I just read, Lordship, the circular basing on which they have asked me? Lordship, the circular is like this. This is a letter from Women's and Child Development Department from Sujata Kartikeyan to the collector Keonjhar in pursuance to the WPC 500/2000 filed by one Sumita Shah versus State of Orissa and other disposed of a filed petition of Sahu thereof. Pursuant to that order, the circular has been passed. What they have done, Lordship, the Balwadi teachers, those who are continuing as such, if they have worked less than 5 years, they will be allowed only 5% of mark for qualifying to the post of Anganwadi teachers, Lordship. In this case, I have deprived of, this is a subsequent circular. This circular, earlier I was continuing as such as the Balwadi teacher. But basing on the subsequent circular, Lordship, they have asked me on the ground that my contending candidate, my opposite candidate, they have secured more marks, Lordship. Lordship, after my, I have given a lecture, Lordship. In this case, Lordship, on November 2010, there is a notification to that effect for inviting application. I apply on 19th December 2010. Then on 13th December 2010, provisional merit list was published, and on till 19th/12/2010, Lordship, there was objection, if any, the department is out. During that time, there was no objection. Then after 7 months, the final merit list was published, and basing on that final merit list, I joined as an Anganwadi teacher in Murudanga Dandasahi Anganwadi Center, Lordship. After 1.5 years, thereafter a notice I received from the office of the ADM, Lordship. That was under challenge where an ADM nullify my appointment, and subsequently appeal approach this honorable court, and Learned Single Judge also confirmed the order of the ADM, Lordship. My point of view is that on a legitimate expectation, basing on the previous circular, I was continuing, and with the expectation that when the center will be converted to the Angalwadi center, and I will continue as such. But subsequent, basing on the subsequent circular, they have ousted me, Lordship. That is the point, Lordship. What counter they have filed, that copy is not there with me. Let them serve the copy. Lordship may call this matter next week.
We don't, the writ appeal is no need for counter rejoinder and all that.
Lordship. They have filed their Lordship, that is on the.
That's okay, we don't have to rely on that. We just have to go by the pleadings in the writ petition. The writ petition, the pleadings are complete. That's more than enough for us.
Lordship.
If your Lordship allows me, my Lord, I'll only place one fact, my Lord. Notification
Go
was
by
issued-
what you have said in your counter in the writ petition.
Notification was issued in 25/11/2010. Revised guideline of 23/7/2010. So therefore, the revised guideline was to be implemented.
Let's say prior to that I was working.
That legitimate expectation that, my Lord,
Prior
is a
to that, I am
misconceived
working.
idea, my Lord. Misconceived complete.
I don't have any information that subsequently there would a notification basing in which they will nullify my appointment.
What is the date of advertisement?
Let's say my date of appointment is.
Advertisement.
Advertisement is
November 2010, much after the new guidelines. The new guidelines were in July, the advertisement was in November.
But prior to that, I was working. Prior to
Okay.
that, I was
The selection
working.
has to follow the new guidelines only. The selection has to follow only the new guidelines. There's nothing wrong in making it order. We'll pass the detailed order. Dismissed. Right.
Item 23.
Item 23, my lord. In this case, your lordship passed detailed order on 14/7/2021, my lord, constituting 3 members of our adverts committee, my lord. They had also earlier given the report, and the final report also they had given, that is it.
We had a visit, my Lord, after your Lordship's order.
Yes.
To Baleswar, my Lord.
All right.
And we have filed a detailed, my Lord, report.
Okay.
With
Where is
regard to
that?
our Baleswar visit, my Lord.
You have the report here?
Report, my Lord, along with report is there, my Lord. We are giving
this one.
Yes, my Lord.
Yes.
Oh.
Actually, this is an interim report.
This is an interim report, my Lord, of the areas, my Lord.
3 of us will place it one by one.
Oh, you enclose the law commission report, no wonder.
No, your lordships, actually, I would, we would like to
It's
start.
very creditable. I mean, the kind of work you people have done, quite amazing.
There's also a pen drive also.
So there are still these waterlogged areas.
Yes, yes, your lordship, we'll actually that report, this report consists of all the colonies. This is an interim report, but it's of all the colonies.
So this garbage, dump yard, open drain and all is in.
It is still there in Baleswar, my Lord.
Baleswar.
If you're-
Yes,
yes.
yes.
That's in Lewis Colony.
Yes. Louis Mamupra Colony, my Lord, in Baleswar.
If your lordship will permit, we'll place it sequentially, then I think.
All right.
Okay. Your lordships, I'd like to start with the question which were probably left last time. The word leprosy affected person, which is actually used in the judgment, is much wider than to be understood that somebody carrying the bacterium merely. It is very important because while we're going through the literatures also, and with the doctors that we spoke, one is we need to understand what the disease is all about, and then look at the term which is being used in the judgment. What happens basically is whenever a person gets this bacteria, the first thing is a sensory loss. Actually, it's a skin disease. So this is not a visible disability, but the NLP, which is a very organic, I mean, it's an evolving guideline all the time, has recently also realized that sensory loss is actually the main disability which needs to be recognized. Meanwhile, why they say so, a person may be free of bacteria, but he carries this condition lifelong. So he will not know the difference in hot, cold, when does he cut himself, when does he get an ulcer. That's why your lordship will see all the photographs. These people, they have such so therefore they are in continuous threat of disability. The doctor with whom we spoke, which we'll subsequently get it in our final report, the video also, who's extensively worked in leprosy area also, she told us that they have nutritional needs which are different, which will require vitamins, certain kind of food. So the kind of assistance that you give to general poor people may not be fitting to them.
I think two broad kinds of types of leprosy.
Yes, there are two broad kinds depending upon the bacteria and the term in which the treatment has to go. But they do have this sensory condition. So that is a very vital thing to understand, that even though they are cured of the bacteria, their medical need remains as long as they are alive. So I think that answers that question which last time your lordships put to us. Giving this background, so they have to be really protected from all kinds of wounds, and so therefore even their capacity building, livelihood, everything has to be seen from that term. Having said this, we will place the report, your lordships. We in fact made a surprise visit actually though it was from 19, but we decided to make a surprise visit to Jatni and Khordha and also Puri. So that was before that, to have a feel. Having visited, then actually this, there are a lot of things that your lordships wanted to tell, but we've confined this report to 15A. That's look at their living conditions. In order to understand what the living conditions, what criteria will pick up, we also went
one thing.
That's page number 2.
In between, there's a move to repeal the act in its applicability. State-wise, the condition was different, is it? Or the act is not there at all now?
We're actually not able to hear you.
No, the act
is not there.
The act is no longer there.
No.
And what is in its place? What is justifying the keeping of all these people in homes?
Yes, there is a background to it, your lordships. What happens is normally the people we spoke to, they would actually leave their ancestral house. And then they have come here and they have just stayed. That's the background.
No, when they dismantled the legislative framework,
yes,
they did not put anything positive in its place.
No, why? Because the fear of the disease to spread always remained. So that community bonding did not happen. It's only recently that the treatments are happening at the residence. Nobody is allowed to be thrown out of their house or go to these colonies.
No, I think my question was different.
I think my lordship is putting a question, my lord, after the act goes, then thereafter, whether there is any legislative framework.
No, correct.
My lord, yes, that is the question your lordship is putting. So lordship, now the new Disability Act has come into force. After the Disability Act has come into force, my lord.
Yeah, that we have.
My lord, thereafter, my lord, there is a Department of Social Security and Empowerment, my lord. That department now is looking after these issues, my lord.
But that act recognizes leprosy affected person, does recognize the disabilities and says that all the benefits, that act is, I think we have also annexed that act.
In fact, that Lepers Act, what your lordship is referring is to the Lepers Act. That has been abandoned by Orissa.
Yeah, this abandoning means what? It's been repealed or what?
It has been repealed. Pursuant to the recommendation of the Law Commission, Orissa has taken
that was a segregating act.
Right.
But this discrimination at the social level still continues. That's why even Pankaj Sinha has recommended for bringing them back to society. So that is still work in progress.
New act, is there any?
No, this back in society, your lordships.
Yeah, there is. That's what he says.
Mr. Mishra, the query is, what is the legislative or the legal framework now within which we are to operate?
Law Commission recommendations have not been fully done by all the states. But so far as Orissa is concerned, they have done away with the Lepers Act.
Right.
No, you lordships want to know the beneficial legislation under which they can come. Yes, then in that case, it will be the 2016 Disability Act.
Right.
And it gives disability has been defined. Leprosy is a heading under that disability.
All right.
That, in fact, we wanted to get it in the final report to give that the final recommendations. But this way, but that's there.
Okay.
In fact, all the yojanas also of the state government recognizes them.
All right.
So therefore, all the livelihood, giving them skill, everything that's there. Okay. But there's one thing your lordships will know, again coming to the medical needs, there was a move, like when the fear came down among the people and a proper treatment came. So then the whole thing happened that we're not going to treat them separately in separate hospitals. We are going to integrate them. Your lordships, integration obviously is a way forward to clear segregation, but there's a problem here, which we, I think, realize on the ground level, is that integration with clear understanding of the different needs I mean, then only substantial equality and justice would be meted out. That has lost complete touch. You know, you need to understand the separate needs. So we do not find that that's coming through any of these legislation. So that will require obviously.
So what is the population? How many people are we talking about?
No, in these 5 colonies, we are not really talking about a very huge population. For example, the colony that I wanted your attention first, Your Lordships, is the Bapuji colony of Jatni. Now, Your Lordship, this has 30 odd families.
So 30 families would be about, what, 5 per family or 3?
No, Your Lordship, there are only 15 patients there.
Oh.
The history being, this is a very old colony. So
Right.
some of them are born to leprosy affected parents, grandparents. So they also, this is historical discrimination. Then you understand historically now they are placed in a disadvantageous situation.
Correct.
So that's there. This colony also has another completely Muslim dominated colony right behind it, only separated through a drain, where 2 or 3 people we found had leprosy, and most of them were actually women population. 1 or 2 of them we found with leprosy, but they also stated that we are here because either our parents had it or grandparents had it, and we have nowhere to go. And that's their life there. They get married there, they have a social life there. So that's how it becomes. But the problem is most of these colonies are in unauthorized land, railway land. For example, this is railway land. So they are always under the fear of eviction. Though government here has come up and has made some toilets and everything, there is some kind of, I would say, a semi-recognition. But the threat is always there. That's one.
This Jatni colony has been there since when?
It's from 80s, Your Lordships. Sorry, more than 80, sorry. It was in 60s, Your Lordships.
All right.
We had that in our diary. I think we should have put that. We'll come up with the exact.
All right.
Most of them only go for begging. So that's their livelihood. And now because of COVID situation, that's a very difficult situation.
Correct.
And most of them told us that they were being taken care by some Christian missionaries. Even to our knowledge, there is some missionary over there run by Mother Teresa's,
Sisters
groups. But then they have also stopped coming because of this COVID situation. But they used to take care of them greatly, come do the bandaging and take care. And most of them you can see, because as I said, it's a sensory loss, which is attacking the nervous system. So, some of them can't speak. They, you might think they're old, but it's not because of that. It's because of this disease. So that's one thing. So
Bapuji colony has 5 people, you said, or 15?
They have 30 families, almost 15 leprosy patients you have.
All right. Now, again, when we say patients, there could be some without any visible signs. Or all of them have visible signs?
Visible, only when they have amputation, they have visible signs. Or they would be like, shaking and everything. But NLP today recognizes sensory loss as a non-visible disability factor. So that's recognized.
So these,
most of them had visible.
No, are there regular visits by medical teams?
No. They only contact point according to NLP, and also that what we found.
None of them has a treatment card, nothing.
No, what they do is that once they get that MDT administered, a certificate is given to them that you have eaten the medicine, that you've taken the medicine. Not beyond that. Nothing happens beyond that.
So they don't go to a primary health center for treatment.
The primary health center is quite a distance, almost 10 kilometers, that's there. The Asha Karmi is supposed to be the point of contact, but then that's very haphazard according to them. It is the Asha Karmi who should take care that the MCR has been given, but the Asha Karmi is a hugely, she's hugely, I would say, burdened post because they look after everything. Including detection. So that's there. But it is not on regular basis. Rather in Baleswar, at least you had a semi-ward or something. This does not happen at all here. So what happens is once a while somebody comes, gives them a bandage or a lotion and they just put it. So there is no care. That's a point that we can clearly make out. Then the government assistance is also only that 5 kg rice and the pension that they get.
Where do they get that from?
They get it under a yojana of the Orissa government.
So they have to walk to a typewriter shop and get it, or?
No. So I think sometimes it is distributed. Sometimes it is distributed. Sometimes
last time I brought to your Lordships notice that per day now it is only 85 rupees.
No.
85 rupees per day.
No, that's
Now, how do
It
they get it?
presents.
How do they get it? Do they go to the?
No. There is a person who comes over to that place and gives it to them, my lord. And
person meaning government servant.
yes, government has outsourced it, my lord.
I see.
The housing facility, your lordship will look at the photographs. That's quite bad. That's from page 7.
This is all Jatni.
This is that column that I'm presently talking about.
Right.
We look at from page, in fact, I'll come to page 8, page 9. These are really poor houses. Your lordship, and the height of these houses are so, low that, it must be very difficult for them, given the fact that, they're already disabled. Page 12, your lordship will see the disability. 13 also. And this place really requires cleaning. If your lordship will look at page 8, this is a drain which actually divides that Muslim community from the leprosy colony, which is identified as leprosy colony, page 8. This really requires cleaning. But I would also say that there are many able-bodied people over there. So little sensitization would actually help a community building.
No, these other able-bodied persons are all relatives of people with
relatives, or they are children of leprosy affected or grandchildren of leprosy affected.
All right.
But once the parents get affected, your lordships will understand it's very difficult for them to again, climb that, social and economic ladder.
Correct.
So they are victims of that. Your lordship, of course, they did have access to water, but electricity, obviously, it must be on holding. It's understood. No clothing assistance.
This, like the person at this page 24.
24 is another colony, I think. Yes. That my friend Gautam would probably place it.
21. No. Are we talking for different colony from page 20, 21 and all?
Yes. This colony is confined to page 13. The photographs are confined to page 13.
Okay.
I think
this is Dharavati colony.
Yes. Mr. Gautam should place.
I'll just apply my lord. If my lord states the compilation, the index of the compilation.
Right.
I hope I'm audible, my lord.
No, you are.
Now, my lord may take up, my lord has directed 6 colonies in all.
Correct.
Those are mentioned, my lord. That serial number A is Bapuji colony, that is in Jatni. Then adjoining that colony, we have Dharavati. That's just the side of this Bapuji colony.
Right.
Then Bhagavat Leprosy colony is at Khorda, which is about 50 kilometers away from Jatni.
Right.
Then Puri, we have Sanjay Leprosy colony. And the other one, Jivaramji Leprosy colony, that's at Puri.
Right.
And then the 6th one, of course, Baleswar, we had dealt with earlier. We also have a follow-up report.
Right.
So now, in this report, what we have done is, we have mentioned about the actual living conditions and then given the photographs. And then colony-wise, we have given recommendations because every colony has separate needs.
True.
So those recommendations would be there from page 44 onwards. Now, if my lord would see, most of these colonies have this basic requirement of improper houses, cleaning, and 4 out of 6 colonies have land issues. Now, if my lord would take up the Law Commission report, that is a part of this also. They have identified this right way back in 2015. If my lord would take up that Law Commission report, that is page 78. Now, what Mrs. Rath said, in fact, a brief summary would be there at page 78 of that compilation.
Right. Correct.
Now, understanding leprosy, they have analyzed in basic terms. Then, if my lord would see, para 2.1.2, they have mentioned how it is transmitted. Like last sentence of that, an untreated person suffering from leprosy can spread the infection through the passage of air. According to sources, more than 85% of the affected by leprosy or non-infectious do not spread leprosy, while over 99% of the world population has a natural immunity or resistance to leprosy. Now, last line of page 79, first paragraph, the incubation period of leprosy ranges from 5 years to as long as 20 years.
Right.
Then, of course, they have mentioned about how the different kinds of leprosy, my lord, grade 1, grade 2, all that my friend submitted, that's there in written form in para 2.1.3. Now, what would be important, my lords, is para at page 80, para 2.2.2. Leprosy is not a hereditary disease and is not caused due to impure so and so. Further, even though leprosy is a chronic infectious disease, it is neither difficult to diagnose nor hard to treat. The main consideration for an effective leprosy treatment is an early detection and regularity in treatment. Then they have mentioned about cleanliness, how the surroundings also have to be clean. That is para 2.2.3 at page 81.
Yes.
I'm just showing the relevant paragraphs for the purposes of the recommendations made in this report.
Right.
We would have to come back to this again and again. But for today, my lords may see these paragraphs only, my lords. It is quite an exhaustive report. Now,
right.
At page 83, my lords may kindly see. Paragraphs 2.4.1 and 4.2, wherein they have specifically mentioned that it is now a completely curable disease. At page 84, first line, it is now a completely curable disease that can be rendered non-infectious in the initial stages of the treatment itself. Now, my lord, may I just show, I hope my lord is getting that at page 84.
Yes, NDT.
My lords. Now, thereafter, my lord may see page 85, para 2.4.5.
Yes.
Here, this is regarding social stigma, my lord.
Right.
And they have also dealt with this aspect, the stigma and discrimination. And then last line at page 86.
Right.
This is something which is which would be common for all these 6 colonies. Now, in many spheres of life, the world over, including India, the process of outcasting of persons affected by leprosy continues to take place, although the scale of such process has considerably diminished in the light of the growing awareness regarding the disease.
Yes.
So it is because of this outcasting that we have all these 6 colonies in different areas of they are mostly at the outskirts. Now, regarding the land issues of 4 of 6 colonies, my lords, this is what the Law Commission says at page 113.
Land rights.
Land rights. Now, what they had said in April 2015 would squarely apply to all these 6, all 4 colonies out of 6.
No, what is this TLNTI, the footnote? What is that?
That, my lord, is one of the leading leprosy organizations, my lord, of India. It's known as the Leprosy Mission Trust of India.
Oh, I see.
It is one of the leading NGOs recognized by the government which works for eradication of this leprosy.
No, where is it located? Any idea?
I think Maharashtra, Your Lordships. I've gone through the website. They really do good work.
Done extensive work. It's a NGO, my lord. I think they have been dealing with this from a very long time.
Right.
It is Leprosy Mission Trust of India, man.
Right. Okay.
In addition to this, we have a lot of like Nippon Foundation from Japan. They are based out of Delhi. They have come up with their reports. So many
International
NGOs
Federation of
also
Anti-Leprosy Associations. Correct.
My lord. Even Orissa has a leprosy association here.
All right.
Now, regarding this land rights, these two paragraphs would be important, my lord.
Yes.
At page 113, they have identified the reason why these people stay in these kind of surroundings and why there's hardly any improvement in this land.
Right.
The entire thing would apply to 4 colonies, my lord. If my lord would see 7.10.3, this practice reinforces segregation and deprives the persons affected by leprosy and their family members from owning or possessing property.
Right.
These colonies are either established on government land, including forest and railway lands, or private land given for the purposes of establishing such colonies by private individuals or institutions.
Right.
Now, in these 6 colonies, my lord, if my lord would see,
yes,
Bapuji colony is on government and railway land. Dharavati colony is in government and / railway land. Then Bhagavat leprosy colony has been regularized. So Bhagavat leprosy colony doesn't have any land issues.
Okay.
Then Sanjay leprosy colony is railway / government land, locked up in dispute. Then Jiburamji leprosy colony of Puri, that a private individual has donated land, their land issues are not there.
Okay.
Then Baleswar, my lord, again, private 9 acres of prime land of Baleswar donated by an individual. It's working well, no land issues at Baleswar.
Oh, I see. All right. So basically the Puri ones have land issues and Jatni.
Puri, Jatni have land issues.
Right.
Puri 2 colonies and Jatni 2 colonies have land issues.
Right. Right.
So what we would be probably indicating is that if this land issue is resolved, from there we can take it forward. Till that is resolved, no further development is taking place in those areas.
So land issue is one.
My lord. And
All right.
for that, we would rely on these 2 paragraphs of the Law Commission. The government, of course, has schemes like the Biju Pakka Ghar Yojana and all, where they can give land to these people.
Right.
Now, my lord,
What about the immediate health needs? Is there any specific recommendation?
Yes,
what I'm having in mind is like, if you have a health card given to a person, which should be a lifelong, because from what you say, it has to be a lifelong treatment, correct?
Correct, my lord.
So, if they devise a health card system, wouldn't that help?
Yes,
Now, my lord, we have actually found it very difficult to start with the basics. Now, hygiene, roof, because Baleswar, my lord, those people don't have a roof to stay.
What I'm saying is, if we can develop on Baleshwar and make it the model kind of a thing,
my lord,
we can ask them to replicate that in all the other colonies.
My lord, in fact, what falls from a lordship will work around that and take up the best practices which is prevalent vis-a-vis these health cards.
Correct.
Now, my lord, may kindly see the recommendation of the Law Commission at page 114 regarding land, my lord.
No, I've noted that. Actually, we need to ask the government to come back on this.
Yes, my lord. Yes, that's precisely our recommendation. Now, regarding the visits by Asha Karmis, that is backed by the NLEP, my lord. If my lord wants, I can show those documents. I'll just quickly run through them. In fact, my lord would have an idea as to how that is functioning. That my lord would see at page 143. Because Pankaj Sinha, my lord knows, has said that NLEP has to be implemented.
Yes.
Page 143, the milestones of NLEP have been mentioned, my lord. Now, this in 1983, this NLEP program that was started.
Right.
Now, my lords may see on that same page, 1948, this Hind Kush Nivaran Sangh that was established. Now, my lord knows that Baleswar is one of the properties which was actually managed by this Hind Kosh Nivaran Sangh.
Right.
Now, thereafter, if my lord sees 2014 at page 144, 2014 independent evaluation of NLEP by World Health Organization. This took place. Then April 2015, the Law Commission report came about. That's not there in this. Then 2016, the Rights of Persons with Disabilities Act, this came about. Then post that we have these new initiatives. And in 2018, we had the directions of Pankaj Singh.
So this absence, whatever, the ASHA-based surveillance,
my lord,
this is only a surveillance or it's also meant to actually?
My lord, actually there are two phases. One is a person who has the disease, they have a separate set of rules. Then once they are cured of it, they are known as leprosy affected persons. After they are cured, they are given a certificate. Post that, they need some kind of monitoring, which is also to be done by the ASHA Karmis and health workers.
All right.
So that also I would show, my lords. Now, my lord, may kindly see page 145, the activities of the NLEP, my lords. At page 145 of that volume.
Yes.
Now, the activities, what would be relevant at this juncture would be capacity building, that is training of health staff like medical officer, health workers, health supervisors, laboratory technicians, and ASHAs to develop adequate skills for diagnosis and management of leprosy cases.
Actually, I think what we're doing collectively is actually auditing all of this.
Yes, my lord, we are actually starting from scratch.
Finding whether it's working or not. And
my lord,
actually, the government should be doing these audits.
There is also a recommendation for a commission by the Law Commission to have a commission to see implementation. That recommendation, if my lord wants, I'll just show that from the Law Commission report.
No, but that actually, that kind of more and more institution building is not, I don't know whether that model works in India anymore. It's mired in its own problems.
My lords, probably they have to have the right man manning those institutions. Otherwise, it would just be a paper kind of a thing.
Yes.
So, what would be important here would be, my lords, this capacity building is required in Orissa, my lord. This is something which probably is not there. Then, disability prevention and medical rehabilitation.
No. So, when we talk about NLEP in Orissa,
my lord,
we only have to go back to the health department here.
My lord. In fact, in my lord's order dated 14/7/2021, in paragraphs 13 and 14,
yes,
my lord had given specific directions.
Correct.
Probably we have not received any affidavits in terms of these directions at paragraphs 13 and 14. So that is probably what my learned friend Mr. Sahu can apprise, my lord. There were specific directions to be like the Director Health Services Odisha to give these specific things.
That's right.
Para 14, my lord, it is
So we have not had an affidavit from the Director Health Services till now.
I haven't received, my lord. I'm not sure whether
Mr. Sahu. Mr. Sahu.
Lordship, please. I'm just checking.
See, we're also lost on the population in Orissa of persons with leprosy. Because we seem to be
the figure would be around 90.
Focusing only on Khurda, Puri and Baleshwar.
Look, there are 93 leprosy colonies which are there in the state of Odisha.
My God.
And out of that, a population of around 10,000.
8,000?
10,000.
10,000. Wow.
These are rough ballpark figures, my lord.
As your lordships were actually asking, actually the Lepers Act was actually an act which deliberately segregated them.
That's right.
The beneficial legislation is 2016. I had read it, if your lordships allow, it actually gives you handle and imposes obligation for the government to do everything, including the land issue. Because it uses a very nice term called barriers. The barriers here have been said, that means any factor, including communicational, cultural, economic, environmental, institutional, political, social.
This borrows the conventional language.
Yes, attitudinal, structural factors which hamper full and effective participation of people with disabilities in the society. And it uses the word leprosy cured persons.
Right.
And also recognizes that sensory loss.
Right.
It gives your Lordship, this act is actually, when I read it, and I was very happy actually, because it's quite a progressive act. If they really implement this, a lot will happen.
No, so why don't we pick up, let's say, since we started with Lewis Colony.
There is a scheme under this act which government has come up with.
My lord, I have already handed over. My lord, a state level technical committee has been constituted. Lord, may kindly say I have given a copy of the state level technical committee and its mandate, my lord. So the 2019, my lord.
Right.
And today also I have handed over, my lord, an umbrella scheme for rehabilitation of the cured leprosy persons. That's of 23rd February 2021. Lord, may kindly come to this objective of the scheme of the state government, my lord, is to ensure equitable justice for cured leprosy persons. The rehabilitation of cured leprosy persons scheme will focus on the following broad objectives: ensure equal opportunity, equity, social justice, empowerment of cured leprosy persons, promote voluntary actions and
participation. So they are talking of multi-purpose smart cards.
Lordship. And Lordship, may kindly come to the program component. May kindly come to the page 2, my lord, of the program component. There they are talking of survey and identification, assistive devices, assistance to parents, pre and post-matric scholarships.
No, my point is, can we at least get this all done in one place?
Colony, my lord. Yes, my lord.
And then
it's a model colony.
Repeat.
Yes, ma'am.
That's one way of going about it.
Yes, ma'am.
Yes, what falls from your lordship, that can be, Baleswar would be the right.
Correct.
And lordship, my lord's query regarding that 14.7 order, I find no affidavit has been filed.
No, so Mr. Sahu, I think we'll do what we did with some other matters.
Lordship.
Give me a date on which the health secretary can also appear before the court. And let's take this whole thing forward. Because if what Mr. Tripathi says, all this is there, the scheme is there, there's some committee is there. Who is that commission? Which is that other notification constituting the committee?
State level technical committee, my lord. I have given a copy of that. The two.
That is under which department? For us, that my lord is asking. That state level committee, Mr. Tripathi is referring.
State level committee of 18/4/2019, my lord.
18/4/2019.
My lord.
18/4 you have not given?
I have given, my lord. There are two papers.
No, is that committee functional? Have you met anyone from that committee?
We have not met, my lord. The committee has only have some kind of a mandate, my lord, but the committee has not yet, my lord, sat thereafter, my lord. We found the first meeting and the second meeting has only taken place.
Mr. Tripathi, that committee is under the
committee is of the principal secretary, SSCPD department is the chairman.
There is a department, social security and empowerment of persons with disability.
Social empowerment, Mr. Sahu.
Yes,
social
sir.
empowerment.
That's it. It is
So
social.
it doesn't have any civil society participation.
Yes.
That could be, my lord. That could be there.
It has only a participation of the HKNS, my lord. The Hind Kushta Nivarana Sangha, my lord, a society which is registered under the Society Registration Act.
That's Mr. Thagada's.
My lord. Lord, so may I kindly come to the, my lord, to the committee which will undertake the following functions. Lots of, I'm handing over, my lord, a copy of the, say, my lord, what's it?
Mr. Sahu, can we ask this, at least some members of this committee also to remain present?
Yes, your lordship, the
Or
secretary.
we'll ask this
directly-
committee to meet immediately?
Yes, my lords. And the secretary of that department may be asked, my lords. Social security, my lord, I am looking at the government agenda. That department is.
You can do one thing, your reports.
Yes.
Mr. Mishra, the report submitted by you,
My lord.
let the committee deliberate on that.
In fact, my lords, what I would suggest is, now in this report, what we have actually, now that we have got what my lord wants,
yes,
we come up with exhaustive recommendations for the committee to deliberate, because this report basically deals with basic things for these people.
Yeah, but let it also, I'm saying,
yes,
this is like short term.
Now, my lord may kindly see that committee which has been constituted on 12/2/2019, that is pursuant to the directions of the Honorable Supreme Court in Pankaj Singh. Now, they have conducted one meeting and thereafter probably things have fallen apart.
No, so the first step is to get this committee to meet now.
My lords.
There are two meetings which are being held. One meeting was held on 6th July 2019. The second meeting was held on 6th February 2020. The two meetings which have been held.
But clearly we don't know what has happened.
My lord.
All right.
My lord, in fact, if the affidavit comes in the light of what your lordship had said in paragraph 14,
yes,
then many things would be clear.
No, so he's also sitting in this committee, the same commissioners and secretary health and welfare welfare. So
now, regarding the colonies, would might not like us to show the recommendations.
Yes, all right.
That is something which at least would bring in some development in those colonies.
All right, tell us.
Now, that my lord would see the recommendations begin from page 44, my lord. They are all very basic. I think Mr. Sahu will not require any have objection to this page 44.
These recommendations can be made by collector.
Page 44. This is regarding the Bapuji colony at Jatni, my lord. Now, these MCR slippers, there's a direction by the Supreme Court at page 45 that none of them are getting, man.
Right.
So, if that can be just directed, then my lord's basic cleaning, serial number B, would be requesting the removal of garbage. Serial number B at page 45.
Correct.
Serial number C, my lord, is land. We have just recommended that let the collector look into it and come up with a solution.
All right.
That is land, my lord, serial number C. Then serial number D, toilets. Let them come up with something that area requires toilets. Only 2 toilets for around 200, 300 people are existing, my lords, now.
So I think it's common to these similar recommendations you've made for the other Dharamati.
Yes, my lord. But these are all colony specific because some of the colonies don't require so much.
No, I know. But the MCR footwear is for all the colonies.
Correct, my lord. That in fact we probably are thinking that there is some problem at the entire in all these districts. None of them are getting these MCR 1 and 2 footwear.
Yeah, basically visits by trained leprosy workers, paramedical workers. I think this is uniform for all the colonies.
Yes, my lord. And that's from the NEP.
Yeah, footwear is common. Toilets, most of the colonies need toilets.
My lord.
Drainage.
So that we have recommended whatever is like Bhagwat leprosy colony doesn't require so much. So we have cut down on the recommendation.
Page 49, Lordship may kindly come. Page 49 of our report, my lord.
Right.
Relating to that Puri, my lord, Sanjay leprosy colony. Lordship may kindly come to Para D, my lord.
I know. So it ties up with that other thing.
My lord. He is there today.
That's true. Amazing.
So, in fact, for the convenience of my lord, we have come up with translated videos which have been given in a pen drive that my lords can also look at to know the problems of these people.
No. So I'm going to ask even those videos be handed over to this committee to watch.
My lord.
Fix a date for the committee to meet. I think that's the best.
My lord.
All right.
My lord, what I would suggest is the policy framework is there. We are looking at execution. So let the committee give exact dates for when they will implement this.
That's right.
With specific reference to the Disability Act.
Correct.
Let's one suggestion. Let's one suggestion. May I submit, colleagues?
Yes.
Lordship, the recommendations at pages from page 44 to 51, they will be carried out by the collectors of the respective districts. Khurda, Puri,
Yes, should.
And the CDM and PHO. So those directions may be issued. And apart from the committee in considering all this.
Correct. You see the
my humble submission before RC, my lord, the report copy of the report may be supplied to me, my lord.
All right. You see the three amicus curiae have submitted a second interim report on the actual living conditions in the 6 colonies, leprosy colonies that they visited. That is the Bapuji and Darabati leprosy colonies of Jatni, the Bhagwat colony at Khurda, Sanjay colony in Puri town, the Jiva Ramji colony in Puri, and the Louis colony in Balashur. The report has photographs of the actual living conditions in each of these colonies. As regards Louis colony is concerned, the photos enclosed show the improvements carried out as noticed by the committee in their second visit after this court's directions on 9th August 2021. Sorry, on 16th August 2020. Correct. In light of the said report, a copy of which we also provided to Mr. Agada and counsel for the petitioner within 2 days, the court issues the following directions: implementation by the collectors of Khurda and Puri, as well as the chief district medical officers of these 2 districts, :1. The residents of the above colonies be immediately provided NCR footwear of grade 1 and grade 2, keeping in mind the requirements of the residents. What would be a reasonable time estimate? 8 weeks? 8 weeks should be reasonable, within 8 weeks. All steps for requisitioning such footwear and furnishing the residents that require it should be completed within this period. It may be noticed that such footwear is essential not only for persons who continue to be affected by leprosy, but even those fully cured of it. 2. The report mentions the reports and the photographs in the report show that there is garbage and unwanted debris lying all over the colonies. There are also open drains which need immediate attention of the municipal authorities. The collectors will ensure that the sanitation workers are deployed to engage with the municipality, are deployed on a regular basis to ensure the removal of all
garbage and unwanted debris, and cleaning of the open drains, particularly given the present monsoon months. 3. There appears to be a need for additional toilets in the colonies, in the Bapuji colony at Jatni. It's in the Bapuji and the Naravati colony in Jatni. And the Sanjay colony at Puri. So particularly in the Sanjay colony at Puri, there should be an immediate discontinuance of the system of dry toilets and their replacement with water flush toilets. The system of dry toilets is prohibited under the 2 statutes that are in force, namely the Marriage Scavengers, the 2 acts. This direction should be strictly enforced without any delay. In all these colonies, the committee has noticed that the visits by trained leprosy workers, paramedical workers, multi-purpose health workers, as is mandated by the National Leprosy Eradication Program, NLEP, is sporadic. The collectors of both districts will ensure that, and the CDMOs of both these districts will ensure that there are regular visits by these persons to each of these colonies. At least, should we say once a week or?
Once a week, Magoo.
At least once a week. The court will be informed by the next day of the actual implementation of this direction by production of the registers maintained of the visits by these health workers to the various colonies. Paragraph. There are other recommendations in the report which in the considered view of the court requires detailed deliberation by the technical committee constituted by notification dated 12th February 2019, issued by the Department of Social Security and Empowerment of Persons with Disabilities, Government of Orissa. The court is informed that this committee has met only once in 2019 and once in February 2020 and not thereafter. The court directs that what is DSSO translate as?
District Social Security Officer.
I see. The District Social Security Officer, who is the convener of the said committee, will immediately issue a notice for a meeting of the committee in consultation with the chairman, that is the Principal Secretary, SSEPD Department, on any date between 20th and 24th September 2021, or 20th and 27th September 2021. A copy of the reports submitted by the amicus curiae to this court. This is the second report, right?
Yes, my lord. This is the second report.
Copies of the two reports. The first interim report dated 3rd August 2021, and the present second interim report will be made available to the convener. Do you have a soft copy of this?
Yes, yes, my lord. Oh, yeah.
Both in a hard copy and a soft copy. Yeah. So that it is also made available to every member of the technical committee for deliberation on the issues raised in both these reports on a range of issues, on a range of topics. Full stop. In particular, the court would like to draw the attention of the said committee to the recommendations regarding the land issues, particularly in light of the specific recommendations of the Law Commission of India in its 256th report, April 2015, on single quotes, eliminating discrimination against persons affected by leprosy. Unquote. The committee should deliberate on the implementation of the single quotes rehabilitation of cured leprosy persons, unquote, scheme that was notified by resolution dated 23rd February 2021 of the Department of Social Security and Empowerment of Persons with Disabilities. This should be also done in light of the mandatory requirements of the Right of Persons with Disabilities Act 2016, which is the current legislative framework to deal with these issues. Anything else we need to say?
Lordship, only one point I want to bring to your Lordship's notice. Lordship, I kindly see your Lordship's last order, wherein with regard to the Kacha houses, my lord, because the monsoon session was there. Lordship, I kindly see your Lordship's order number 20. The directions were issued to the collector Baleswar and CDMO Baleswar, my lord. Clause 4, my lord, clause IV. Given the current monsoon session, repairs to the Kacha in the area to be undertaken immediately by engaging the empaneled civil contractors with the PWD, my lord. During our last visit, my lord, what we found is that the contractor, the PWD executive engineer, told that since there is no funds allotment, so therefore they are not being able to come up with that, my lord, colony. So Lordship may kindly, my lord, direct this to be expedited, my lord.
All right. In fact, those recommendations vis-a-vis that colony would be at page 66. Page 66.
Right. Okay.
I think we have a separate, separate paragraph. Can take instructions that would be there, because we have also requested for increasing the number of houses.
Right.
But at least as Mr. Tripathi said, those houses have to be constructed at an early date. Now they are without. If my lord would see the photographs, these people are without any houses. If my lord would see the photograph, my lord, at page, I'll just show that one. Page number 54.
No, so I'll issue those directions for Lewis colony. As regards to Lewis leprosy colony, the following directions are issued to the collector, Baleshwar, in continuation of the direction issued in para 12 bracket Roman small 4 of the order dated 9th August 2021. The collector is directed to ensure that funds are released for the civil contractors of the PWD to take up the work of effecting repairs to the Kacha houses in area 2 immediately.
And if allowed, the toilets which are in the process of being constructed, they should have appropriate availability of water, my lord. Otherwise, they will not be able to make use of it. We found there is
60
no
houses
water
with
facility.
galvanized sheets, ceiling, electricity and fan for persons staying in the entire colony be erected. In a time-bound manner within a period of 8 weeks from today. 3. The filling up of dump yards and removal of garbage should be expedited. 4. The toilets being constructed should be provided with overhead tanks for uninterrupted water supply. What is the strength of HKNS accommodating?
Now, the HKNS manages 33 people only, whereas there are actually about 47 to 48 people who need food as well as shelter. So this recommendation of HKNS is pending before the government. They have asked that you give more numbers to us.
All right. The request by the HKNS for increasing the number of patients entrusted to their care from 33 to 60 be immediately examined by the government, by the collector, right?
By the collector. Collector would be the right.
And be accepted by passing appropriate orders. So all of the above steps be completed within 4 weeks from today. Should we call it once in October?
My lordship.
Yes.
Before the vacations?
My lordship.
All right.
And my lords, that affidavit in terms of the first order.
Yeah, the Special Secretary Health will comply with the direction issued in para 14 of the order dated 14 July 2021. The Director of Health Services, the filing an affidavit before the next date. I think there's only one possible date, which is 7th October. Or list on 7th October. Copies of these orders, this order be made available to the CDMO and collector of Khurda, Baleshwar and Puri and the convener, that DSSO by special messenger. Forthwith.
We are all grateful.
Right. Thank you.
Excellent. Item 24. Item 24, I am for the opinion number 2, Walkman.
Who's for the petitioner?
My application at flag is pending since 2018.
No, we're waiting for the petitioner. One minute, Mr. Mishra.
Dated order number 8. He rendered no instruction, Your Lordship. That is the order reflects. Order number 8 dated 25/3/2021.
Oh, I see.
Thereafter, again matter was on 29/4/2021.
Right.
He appeared.
Right. None appears to the petitioner, none appeared in the previous date. Dismissed for non-prosecution. All right.
My lord, may I pray to
Sorry? You have to unmute yourself, Mr. Mishra.
I'm sorry, Your Lordship. Automatically the interim order stands, must do the final order.
Yeah, all interim orders stand vacated. Order.
Obliged.
Item 25.
I may plead your lordship.
Yes.
The opposite partner 5 was the applicant before the Central Administrative Tribunal. The background of the case in short is that there was a limited departmental competitive examination in the concerned authority, one of the concerned authority. And the stipulation was made for appointment, the educational qualification as prescribed in the advertisement was nursing midwife. And he must have completed 3 years diploma. The opposite party number 5, who had no qualification, filed the original application challenging the advertisement. Be that as it may, logically turn to page 62. Page 62, my lord, paragraph 12.
May I interrupt, my lord?
Yes.
Matter was listed since long. Thereafter, the brief of the writ petition is not available with me. In the Union Friendship Party, it was listed since long 2017. Thereafter, it was listed. There's a direction to serve the copy. Might have served the copy, but
Union will support me because
maybe, but I didn't have a. Your lordship will educate me.
Yes. Counsel, the petitioner will serve on Mr. Padi. The counsel for opposite parties 1 to 4. Another copy of the petition. Reply, if any, be filed within 8 weeks, rejoined for the next date. Interim order to continue. Rest after 12 weeks.
Item 26.
Please, your lordship. But here the opposite party number 6C has died. So we filed an interim application number 9870 of 2021.
All right. For the reason stated therein, the application is allowed. And opposite party 6C is substituted by the LRs as indicated in the schedule. The amended cost type, consolidated cost type to be filed within a week. But the same persons will appear, I suppose?
But the same learned counsel may appear, my lord, because the...
Who is appearing for the opposite parties?
Lord, I am appearing for the 6A, C and D.
Okay, fine. No, are replies to be filed or pleadings are complete, right?
Yes, ma'am. Pleadings are complete.
All right. Which is listed for hearing.
Yes, ma'am.
All right. Then we simply say list after 12 weeks. Right.
Item 27.
There, please, your lordship. The 6 persons before your lordships are street vendors who are operating in the old guest house in the Koraput area, and they were evicted therefrom for the purpose of construction of a supermarket complex with an assurance that they would be accommodated once the shop market complex is completed.
Have they filed replies?
The reply, rejoinder, everything is complete. All pleadings are complete.
All right.
Your lordship may, just the background is, your lordship may first.
Shall we just run through the list? Because we have a very long list. We can run through the list and then come back to this.
Okay. I'll wait.
Your lordship, only one submission. I filed an additional affidavit yesterday. That is not on record, as I see from the list. So
I'll get a photocopy thereof and supply it to your lordships.
No, I also have got photocopies. So if your lordship, because that is not on record, that is the only.
You don't need to respond to that.
No, I don't need to.
All right.
That helps me.
All right.
Item 28.
May I please, Your Honor?
notice is served to the opposite party number 2 to 10, but the AT is not back from respondent number 3, 5, 8, and 10.
Fresh notice.
Malad?
So you have to issue fresh notice.
Malad,
Your Lordship, I kindly see in the writ petition, there were 5 opposite parties. But in writ appeal, additional parties have been added.
How's that?
I am for OP number 2, Ridco.
And I have entered appearance for OP number 6 to 8, my lord.
After 46 years,
Lordship,
a writ petition was filed, my lord.
Oh, I see.
And that has been
6, 7,
rejected.
8. I think 6, 7, 8 are the same as 10.
Correct, but they're all appearing now. Why did you come to the impugned order and tell us what is wrong? Come to the impugned order. Yes.
Learned counsel for the petitioner contended that the husband of the petitioner, who was serving under Orissa State Electricity Board, died while continuing in service year 1976. After a long lapse of more than 43 years, the petitioner has filed this writ petition. It is also contended that the benefit has been extended to the adopted son, but the benefit has not been given to the petitioner. It is further contended that despite several representations were filed by the petitioner to the authorities, when no action was taken, the petitioner has approached this court by filing the present writ petition. Then, considering the contention raised by the learned counsel
Right.
for
So
the
what is your
parties-
explanation for the delay?
Madam, in my writ appeal, I explain everything. Para 3, my lord. In my writ appeal, consolidated copy, page 3 and para 3, my lord. That the appellant is an illiterate, poor, law-learned lady and belong to backward class ST. After the death of her husband, by doing household work, she fulfilled the basic needs of their family. One friend of her husband told that she also got pension benefit death claim because her husband died on the spot during the course of his employment and he was a government employee. So requested to the authorities, due to illiterate, she make representation before the authority orally and written by others.
You are
Since
the wife. You are the wife of the deceased employee.
Malad.
You came after 43 years.
Malad.
6 years. 46 years.
43 years.
43 years. All right.
But why this delay is committed, I explain everything in my writ
So what is
application, Malad.
it? You have not been paid with your death benefits and gratuity, etc.
Malad?
You have not been paid any death benefit.
No, they engage after a very long period. My son, my adopted son, in 2017. But till yet they not give my pensionary benefit.
That is regarding rehabilitation appointment.
Malad.
But you have not paid her any.
But till yet they did not give my pensionary benefit.
Your Lordship, I kindly turn to page 10 of the writ appeal. He was appointed as an NMR employee. Subsequently, my lord, he was engaged as a temporary. He was not holding any substantive post.
So he is not entitled. His
Yes, my lord. So
her
therefore,
husband was not entitled.
yes, my lord.
After the time of death, her age was 13 years. At the time of death of the deceased employee, her age was 13 years. He has to prove his her.
Madam, kindly see. Employees.
So you are also disputing her status as the wife of the deceased employee.
Yes, yes.
No, my learned senior is appearing for NISCO.
No, Gridco.
Sorry?
Gridco.
Okay.
Because by that time that was Gridco. So all disputed questions, my lord. And Lawrence single judge have rightly rejected the writ petition on the ground of delay, my lord. 43 years, my lord.
No, on the ground of delay, it was
will do nothing.
on the ground that was rejected. But I explained everything in my writ appeal, my lord. And how I entitled all these things I explained in my writ appeal.
All right.
And employees family pension scheme 1971 It also explained that how after the death, in the case of a member who being a member of the family pension fund dies during the period of recoverable service.
Miss Sarma, I think you are Miss Sarma.
My lord.
Yes, now what their case is that they are disputing your entitlement.
I am not entitled.
Yes, they are disputing your entitlement.
No, I am entitled because I am the wife of the deceased employee.
All right. All right. We'll pass it.
Next time, my lord.
No. We'll pass orders. Dismissed and we'll pass orders.
29.
With leave of your lordship. Your lordship directed the
No,
state
item
government.
29, I pray for a short adjournment. I have not obtained instruction. Your lordship can see the order dated 22/6/21. Here, there my lord directed to comply the order dated 27/4/2021. Though I have issued a letter, I have not received any instructions regarding compliance. I pray for some time.
I request Mr. Mudali, who needs some time for instructions. List on 1st November.
Okay.
Item 30.
My lord, item 30, my lord, I pray for a short adjournment as well, because I have also received one affidavit from the state and not received any instruction from the petitioner as to any objection, but she has stated that she has objection to this affidavit. For that reason, I need to file one affidavit citing the objection to this.
To which affidavit?
The affidavit has been filed by the state.
You also already filed rejoinder.
My lord, there's no counter affidavit has been filed. This is an affidavit as per the direction of this honorable court that has been and
rejoinder. He wants to tell to reply to this. Okay. Reply to the affidavit of opposite party number 6 be filed within 4 weeks. List after 12 weeks.
31.
Okay, please, my lord, sir. The name of the Lord counsel for the opposite party doesn't appear, but they have filed a counter. Proceed may kindly find the counter affidavit at page 40. I hope it's continuously page marked.
Same RACP.
That's it. Yes, page 42. Page 42, paragraph
Sir,
7.
we've already heard and reserved my orders, isn't it?
My lord, here the date is at issue. So I think the petitioner now agrees for the date. Lordship may kindly mark paragraph 7, but if it's not there, that would be difficult. Page 42, my lord, the paragraph 7, my lord, the 7th line. The OP number 1 has no objection to receive grade pay of 5,400 from 19/6/2014. So this is our prayer in the writ petition actually. Our contention in the writ petition that it should be from 19/6/2014.
Okay. You see,
so
Mr. Sahu refers to the counter affidavit filed by opposite party number 1, wherein para 7 it is stated that it is stated as under A to A. So we dispose of the petition then.
If he's not there, then I think the short adjournment can be granted.
Sorry?
I don't find the learned counsel for the petitioner. In the
petitioner is not there.
No, you are the petitioner.
I'm sorry, I'm the respondent. I'm sorry, the opposite party number 1. I'm so sorry.
Who's for the opposite party number 1? Was he sent this reply?
Mr. Anil Kumar Das, as mentioned in the counter affidavit.
No, in view of the statement, the implead order gets modified, is it?
Yes, your lordship.
It's been issued.
The order actually is a short one.
No, it's called the counter. I've quoted you the counter. No.
This is a repetition. Filing of counter on behalf of my. Some Das has filed. In view of the above statement, the interim order of the OET will stand modified to the above extent. The petition is disposed of.
From 32.
Pardon me, Granted, ma'am. Item number 28 may kindly take up another day, ma'am.
No, sorry.
As liberty may be granted for filing another writ petition, ma'am.
No, sorry, please. Sorry, please. Sorry.
32.
It may please your lordship. I am for the respondent number 1. I have filed objection to the limitation petition. The limitation, the delay is 8 months, more than 15 days. 8 months, more than 8 months and 15 days.
Okay.
This one.
And
Let us hear the petitioner first.
What's the explanation for the delay?
My lord will find when sorry.
Two 22 days.
Yes, my lord.
Para 6, come to para 6.
Yes.
Usual classic explanation.
Here, my lord, that manner, here, lordship will find that the order passed by the honorable single judge. That order was passed on the very same day, first day of this listing, irrespective of the fact that the respondent number 1, respondent has filed.
You have that copy of that order. You have a copy of that order.
102, read appeal number 102 of 2021, your lordships passed the similar type of order with where the honorable single judge allowed the dispose of the petitioner on the first date of its hearing. Read appeal number 102 of 2021.
In a large number of such matters, we've sending it back to the judge because these are first day orders.
Yes, my lord. That is the read appeal number. That is the read appeal number 102 of 2021. Your lordship passed.
Right.
Remanded the matter back to the honorable single judge.
We will make them file the reply before that date.
My lord.
And they can take it up immediately.
My lord, in this particular case, they have taken the ground for condemnation of delay that initially they preferred to file a review. Thereafter, they changed their decision
in a large
to file this
matters. You see, the very first day orders are passed. No counter, nothing.
Now, in fact, the order was passed, the petition was filed on 13/8/2020.
And within 5 days it came up for first hearing.
And the decision was taken on 13/8/2020.
Are you following what I'm trying to tell you?
Yes, my lord.
Are you following?
Yes, my lord.
Are you agreed that this can go back to the single judge so that pleadings can be completed and after that the petition can be heard?
Well, just regarding the limitation, I just want to draw your lordship's attention because in the meantime, the poor respondent number 1 has completed 25 years of service and he's just at the fag end of his career. And these people, they are just, they have taken the decision to, they are yet to take a decision to regularize their service. A class 4 employee, way back to 25 years back, he was appointed and he is continuously rendering service.
Are you able to hear us?
Secondly,
Are you not, you are not able to hear us?
No, I don't think we should compel him to hear us. You carry on, sir, carry on. Carry on.
Only regarding the limitation, I want to say, after 8.5 months, they have filed this case and they were very much present on the day the Honorable Single Judge has passed the order. On that day, they were very much present. We served the copy on them. Let me draw your Lordship's attention to the order passed by the Honorable Single Judge, that is Annex 2 of the writ appeal, page number 36 and 37, wherein in the first line, it has been mentioned, heard the Law and Counsel for the parties. So the Law and Counsel for the state was very much present. In his presence, the matter was, they could have preferred the review within the stipulated period, that we were not given any sufficient opportunity of hearing, and they could not take a decision. In fact, they took the decision to file a review, and they have swear that thing in their affidavit. And thereafter, they said that we could find that the filing of a review is not permissible, so a writ appeal is filed. The question is that just this poor respondent number 1 is looking to your Lordship for justice. That is the point just I want to. It is a question of, I think the poor respondent 1 deserves to take mercy.
It will be listed before the single judge on 1st November. I'll pass the detailed order. All right. The writ appeal is allowed. We're sending it back to the single judge on 1st November. Right.
One thing, with your Lordship's leave, may I just add one thing to it? Your Lordship may say that it will be listed before the Honorable Single Judge along with the WPC OSC 118 of 2019. Because he had earlier preferred the application
that you mentioned
OT.
before the London Single Judge. We will not say.
Yes. That requisition is mentioned.
Item 33.
33, we have filed 2 notes, madam. Sorry. On 33 item, my lord, we have filed 2 notes. Amicus curiae, we have filed 2 notes. Copies of which, my lord, yesterday we could not be able to serve upon everybody, my lord.
But we serve it, then we take it up.
Your Lordship, just one thing. You actually have served on the state.
No, but there are those private parties.
Yeah, no.
There's one private party here.
No, I think the notes. The notes actually is on the point of law. Actually, your Lordships. We'll just look at one note, the first note, your Lordships, which is.
Or we'll keep it tomorrow.
It is only short thing I want to say is that they can just take instructional notes because they've given bulky affidavit saying that this is the. Actually, a lot of things happen after your Lordships really took note of this. They've come up with a lot of policies and everything. But I think none of them have taken into consideration of the standing policies of the central government. So I brought that on record.
Right.
They may as well take this and say that how much they match up to the standards.
Okay.
That's all in that first note is there.
They may come up with that, my lord, instruction with regard to these 2 notes. That's what only we will supply the notes.
So there's a note on SOP.
Flag Q.
Flag G, no? Flag G.
It's filed yesterday, my lord.
No, flag.
Flag Q.
Right. See, the amicus curiae file.
This is SOP, your Lordships. We'll see this annexed. There is an annexure to that.
Notes.
Standard operating procedure by Ministry of Housing and Urban Affairs, the Government of India.
Relating to both the affidavits of the state government as well as the affidavits filed by the BMC, CMC and WATCO.
You've served this on all the council or only some?
We've served it on OP number 1 to 4, who actually going to implement this.
OPs 1 to 4. They be served on the other council before the next date to enable them to respond to it. When can we have this?
The compliance affidavit is at 1 to 4 is at you and the other.
Actually, I feel this kind of thing should be heard on a Saturday.
We can have it on the Saturday.
Any day, any Saturday, my lord.
Any Saturday.
No problem. So 30th October.
30th October.
That's it.
List on 30th October with consent of council for the party.
Item 34. Pardon. Item 35.
My lord.
Item number 38.
May I please your lordship? May I please your lordship?
Yes, please.
My lord, I may be permitted to place the matter on behalf of R. Achari.
Yes.
My lord, here the case of the prosecution is that in brief on 13/12/2007 at about 8 a.m. appellant alleged they have killed two persons, one husband and wife, namely Abhinav Munda and Jagan Munda, in their house. My lord, in this case, to prove the case, prosecution has examined as 7 witnesses, my lord. And after hearing prosecution, Law and Lower Court has convicted the appellant and passed a sentence of life. My humble submission is that, my lord, my case squarely falls under section 300, exception 4. My lord, this case is due to sudden fight, due to self-control.
And in case of double murder, you also invoke 304.
my lord, the case is due to the witchcraft. The Abhinav Kempa, who is that?
Witchcraft is sudden and grave provocation.
Yes, my lord. Abhinav Kempa, who is that Gunya, who is praying for God. He said that Abhinav and that person is witch. My lord, and appellant is an tribal person, my lord. There is no mens rea, my lord. There is no intention. There is no requisite mens rea, my lord, in this case. And he is at the time of committing crime, he is in fragrant mind also, my lord, which is clear by all the witnesses also.
All right.
Hospital 1 to 5 are the eyewitnesses.
Right.
And hospital 8 happens to the doctor.
Anything you have to say anything about eyewitnesses?
Pardon me?
My lord, eyewitnesses are not all 5 is the eyewitnesses who is not clear. He has not seen that incident. My lord, all that say that due to Abhinav Kempia, who is the Pujaka, who said that these 2 persons are witch and he killed your son and doctor. Due to this provocation, unfortunately, prosecution has not prosecuted Abhinav Kempia, who has instigated the appellant, my lord. And my lord, the case is due to witchcraft. My lord, there is a legislation, but this cannot be cured by a penal law. State has to take necessary awareness, my lord. And the appellant is in jail custody since 14 years, my lord.
Yes.
So my case is that there is, I have no mens rea at all, or I am not preparing for committing that crime. That due to that sudden great and provocation of that Abhinav Kempa, who is a Pujaka, who said that these 2 persons are weak.
File is there.
We don't know who is the clear.
Well, I have also cited some judgment of Honorable Apex Court.
Two is clear. Yes, yes.
May I read that judgment, my lord?
Yes.
My lord, in Surendra Kumar versus Union Territory of Chandigarh.
What is the ratio in that judgment?
Even TW7. 1 is at least not so. 7.
What is the ratio in that judgment?
My lord, in that ratio, it is Honorable Apex Court categorically held that if it is a sudden fight and there is no premeditation, act is done in a heat of passion, then undue advantages of the case, then it is not fit for to prosecute the appellant under section 302 by IBC. The case may be on 304 part 2, my lord. My humble prayer to be my lord to consider my case under 304 part 2 because there is no premeditation or there is no request mens rea at all.
I see. Orders reserved.
Plus only I pray your lordship attention to page 55, chemical examination report.
Yes.
That complicity of the accused is very clear, as because from his wearing apparels, the same block 55 loss. Loss can get it.
Hapsat is the wearing apparel of the appellant.
Yes, appellant.
All right.
All right.
Item 39.
May I please your lordship? My lord, in this case,
order number 5 may kindly be seen.
In the last occasion, that is on 25/8/2021, your lordship was pleased to direct the state council to obtain instruction in spite of the order of status quo ante passed by this honorable court as to whether the appellant is working.
Let him answer. Let him answer.
My lord.
My lord, both these persons, my lord, none of them are working now. And my lord, another person was working in adjacent area, my lord.
Look at the story. So it's all pointless.
So that day he should have withdrawn.
It now turns out that neither the appellant nor the opposite party, number 4, right?
My lord.
Is working in the post in question. That is the matter. No orders are called for in the present petition. The questions of law are left open for an appropriate case. The appeal is disposed of.
Posted.
Item 40.
Pardon, my lord.
It's over. It's over.
Your case is over, Mr. Pusti.
Yes.
My lord, I could not follow your lordship.
It has been disposed of as infructuous.
Yes.
Item 40.
My lord, in the order, I may be heard, my lord.
Yes, you have been heard. We have heard you.
No, the order which has been passed by the honorable single judge.
You want that to be preserved or you don't want it to be preserved?
My lord?
You want that order to be preserved or not to be preserved? You want that single judge order to remain or not to remain?
Not to remain, my lord.
You are the appellant or you are the respondent?
I am the appellant, my lord.
What is he saying? Huh? But your appellant is not working.
Mr. Your appellant is not working since last 10 years, what he has said.
My lord.
Then why you want that order should be set aside?
My lord, may I pray, my lord? Well, she is not working and
nobody is working. Somebody else is working. Yes.
Or if it has been infructuous, we have disposed of as infructuous.
Yes.
Item 40.
Item number 40. Lordship may kindly see order dated 8/3/21. And we are before your lordship challenging the valuation of the answer sheets by the valuation committee on the ground that my papers have not been properly valued. And on that day, on 8/3/21, the lordship was pleased to pass an order.
Selection process is over 3 years ago.
My lord, 3 years ago, but still I am entitled to get the relief in view of the fact that I have not committed any wrong.
No, that is not that's in a service matter. That is not the criteria, please.
My lord, there are judgments of the Honorable Supreme Court and as well as of this Honorable Court that because if I have not committed any fault or no fault of mine, I should not be punished.
No, then you'll have to implead every person who selected as a party. Are you prepared to do that?
No, my lord, no, there is no need of that.
Why not?
In view
there is no interim order in your favor.
My lord, there is no scope for me to have an interim order because after the selection process was over.
Normally, the court either says you reserve a seat for this person, or it says the outcome of the selection will be subject to the result of the petition.
Provided
there are several types of interim orders, even matters like this.
That is true, my lord.
There is no such interim order here.
My lord, your lordship may kindly bear with me.
No. So you first produce all that case law which says, despite there being no order to reserve a seat for you, despite no order saying the selection will be subject to the outcome.
Yes.
3 years later, without including anyone who has been selected, you can be heard.
Yes.
You produce a case law.
Yes,
you produce
I am
a case
having
law.
a case law.
Yeah. Counsel of the petitioner seeks leave to produce some case law in support of a contention that without including persons who have been selected, the petitioners can somehow still be granted relief.
Your lordship, keeping it to my
Yes.
Keeping it to next
At
week.
her request, list after 4 weeks.
My lord, may I pray your lordship may keep it to 2 weeks after? If it is possible, 2 weeks after.
4 weeks after, we'll give you a lot of time. You may have to search a lot.
Obliged.
Yes.
Item 27.
What is the additional affidavit?
The affidavit, in the affidavit, they've only stated, after I said that the money is available with them for construction of the first floor, now they have given an affidavit wherein they have stated that they have refunded the money to the government without utilizing the same.
That is as per the government order. Government had directed us that whichever amount has not been utilized, you don't utilize it now and return it to us. I filed a government's letter also. I have whatever I have done, I have only acted in compliance of government's letter.
Does this not change the situation, Mr. Mukherjee?
No, it doesn't matter. It doesn't change the situation because what they are absolutely silent about is the fact that 24 shop rooms have been constructed and have been allotted, and each of the allottee has paid an amount of rupees 2.5 lakhs. So that money is still parked with them, and they are absolutely silent about that. And my lords, besides that point, the first floor, the original plan was to construct 72 shop rooms in 3 floors. They have stopped short after constructing 24 shop rooms, which is not enough to accommodate the persons who were displaced from the places, which includes the present petitioners. Now, my lords, even these petitioners had given a written application to them that we are ready to make some advances to you. You please construct the first floor shop room, and till the constructions are made, kindly accommodate us in the ground floor. There is a 5,000 square feet area.
Do you have photographs of the place?
Sorry, my lords?
You have photographs of the place right
yes,
now?
Yes, I have given photographs. There is a 5,000 square feet area which is now being misutilized. This area is meant for parking of the shop owners for the first and second floor. Now, first and second floor is non-existent. And this place is now being taken over by squatters.
By?
By squatters. I have shown photographs where is that? It shows that it is being used for storing items of other persons.
No, there are no squatters in these photographs. No. Simply empty basements.
My lords, in fact, there was a on my WhatsApp, I received a photograph where a person was sleeping.
One person sleeping can't make a.
The fact of the matter is 5,000.
No, how does this place look when you say accommodate us on a ground floor? What does that mean?
My lords, I have all the plans. The plans I will show to your lordship. That is there, my lords, in my rejoinder, page 20. Page 20 is the plan.
I don't know. This all your photographs show some empty basements.
Yes, my lord. Now, if your lordship sees this plan,
can you get us the actual photograph of how this whole thing looks like now? You said 24 shops have been built, correct?
Sorry, my lord?
You said 24 shops have been built.
24 shop rooms have been built.
Let me just clarify.
As per the plan, which is at page 20.
Let me just clarify. 24 shop rooms, total a market complex was there. 24 shop rooms have been constructed. For the petitioners here, 8 numbers. For those 8 number of shop rooms, we don't have funds available right now because the government asked us to return the funds. That is what I have stated in my affidavit. And the area which is my learned senior is pointing out, that is a parking space. And in the approval plan of the building approval plan, it is already earmarked as parking space. So we cannot go beyond that.
See, his point is we are not using it for parking. You might as well give them shops.
No, it is being used for parking. It is used because.
Can you show us photographs, please? This is what repeatedly I'm asking both of you. He's showing me empty basement. I'm not able to make we're not getting an idea of what it is being used for. You send someone and get the latest photographs.
My lords, page 24 of the writ petition, if your lordship takes. Of the writ petition, page 24.
Page 24 is the last page of the writ petition.
Of the contempt application. The approved plan is there, my lords. of the contempt application.
Mr. Mukherjee, we really want to see the photographs, not the approved plan. Please produce photographs.
I'll file the latest photographs.
Well,
The
I have
latest
given the
photographs
photograph.
of the shopping complex that has now been built.
Your Lordship sees that page, contempt application photographs are there. Contempt application, page 18.
Mr. Mukherjee, I think you're not, he's asserting that there is parking going on there, including
Because the shop
basement
room,
area.
the shop, there are total 24 shop rooms already there.
May I just clarify this position? My lord, 72, when the approved plan I have enclosed. The approved plan shows that the 24 shop rooms in each of the floors and the central area is to be used for parking of vehicles of the shop owners of the first and second floor. Now, they are saying that it is a parking. I do not dispute it's a parking area. It's a parking area for shop owners of the first and second floor, which is non-existent now. So my prayer before them was that allow us to operate in this area, 10 by 10 cubicles you allow us, so that I can earn my...
What is happening in that basement?
No, there are total 24 shop rooms already. Those shop owners are utilizing that parking space. So is that market complex?
All his photographs show they're all empty.
No, they may have been taken at a time when the shops are closed.
Which is why repeatedly I'm saying, anyway, that's the order of the court. You can keep arguing endlessly. The latest photographs of the shopping complex and the basement bracket parking area be placed on record before the next date.
I'll get a video done. I'll give a pen drive.
What? Photographs, videographs.
Right. Lordship may fix a short date.
Puja vacations. All of you should enjoy your puja.
Let them also enjoy the...
In Orissa, Mr. Mukherjee, in Orissa, if I go to say no puja vacation, just imagine what will happen.
My lords, let them also enjoy the vacations, my lords, by getting a shop room before that. Because that is the time, my lords, these people can earn their livelihood.
I know.
My lords,
we're trying our best, as you can see. Yes.
Your lordship, give a date, my lords.
Second.